Please be seated. Welcome back, members of the jury. We'll proceed with trial in the case. The matter before the court today is Casey Draper versus Waco National Golf Club, Inc. and Sterling Family Nursery, LLC. For the record, this is case number TGCV 001-23. It's a pleasure to be able to preside here in the Western District of Texas based on an assignment allowing me to preside from the Eastern District. All right, I'm going to ask for announcements from the parties at this time. What says the plaintiff?
Good afternoon, Your Honor. My name is Nick Lewis, and I, along with my co-counsel, Ms. Emily Johnson, represent the plaintiff in this case, Mr. Casey Draper.
You ready to proceed?
Yes, Your Honor, we are.
Thank you. What says the defendant, Waco National?
Good afternoon, Your Honor. My name is Clark Doig. The last name is spelled a little complicated. It's D-O-I-G. And I'm here appearing on behalf of the defendant, Waco National Golf Club. Today, I'm joined by my co-counsel.
Good afternoon, Your Honor. Beatrice Schaefer for the defendant, Waco National.
You're ready to proceed, counsel?
We are, Your Honor.
Thank you. What's the announcement from Sterling Family Nursery?
Good afternoon, Your Honor. My name is Amin Hosseini. First name spelled A-M-E-E-N. Last name spelled H-U-S-S-A-I-N-I on behalf of the Sterling Family Nursery. And I'm joined by my co-counsel today.
Good afternoon, Your Honor. Michelle Garabetian.
All right, and Sterling National Nursery is prepared to proceed as well.
Yes, Your Honor.
All right, be seated, counsel. Thank you. Before we get on to the evidence, we're going to take up any remaining and unresolved pretrial matters. Let me turn to the plaintiff first. Are there pretrial issues you need to raise with the court before we begin with the evidence?
Yes, Your Honor, there are. We have several housekeeping matters to take up before the court and then 2 motions in limine.
All right, what are your housekeeping matters?
Your Honor, may we consider that all the witnesses have been pre-sworn?
Without objection from anyone, I think that's fine.
And Your Honor, at this time, we would invoke Rule 615 to sequester all witnesses barring party representatives. And for the court's notice, our party representative is Mr. Casey Draper.
All right, you're effectively asking to invoke the rule. Is that what I understand?
Yes, Your Honor.
Any objection?
No objection, Your Honor. Just one point of clarification. Given the layout of the courtroom, it's a little bit tight. So we do have our party representative just sitting right back there, Rory Campbell.
All right, well, the party representatives are entitled to be present.
Yes, Your Honor.
It's those witnesses that are not party representatives that I assume you're concerned about.
Yes, Your Honor.
Okay. Are those non-party representative witnesses going to be present in the courtroom? Or are they going to be sequestered outside the courtroom?
We're asking that they be sequestered at this time, Your Honor. We're happy to do it constructively if that's easier for the court, but we can also sequester them outside the courtroom as well.
Well, this is not my usual courtroom, so let's just do it constructively.
Yes, Your Honor.
All right. What else do you have?
Your Honor, I do apologize.
Go ahead.
Would I be able to clarify one thing related to invoking the rule? I believe the remaining 2 witnesses are actually experts, so they're not covered under the invokement of the rule, so they actually would remain in the courtroom constructively and in reality.
All right. Do we have non-expert witnesses that are not party representatives that otherwise would fall under the rule?
No, Your Honor.
Anybody else aware of any witnesses of that type?
No, Your Honor.
No, Your Honor.
All right. Then I think we're covered. Experts and party representatives are welcome to be present in the courtroom during the testimony. If there's any witness that falls outside of that category, then they need to be excluded. And since you've represented there aren't any, then I don't think we have anything to worry about.
Yes, Your Honor.
All right. You have other housekeeping matters, plaintiff?
Yes, Your Honor. We would ask at this time the court's preferences on movement about the well.
Well, I'm going to give you some latitude in that regard, especially considering the layout of this courtroom and the proximity of counsel to the jury. Obviously, the plaintiff is very close to the jury box. Waco National's in the middle, and then Sterling Family Nurseries is way over here on the other end. I'll allow you in the well of the courtroom. I don't want to get any closer to the jury than the corner of plaintiff's counsel table. But from the corner of plaintiff's counsel table to the other corner where Waco National is seated, that space is fair game as you might want to use it.
Yes,
All right?
Your Honor.
Anything else?
Our final housekeeping matter is may we consider that all of the exhibits retain their original pre-marked numbers?
Any objection from any other party?
That'd be best for us, Your Honor.
No objection, Your Honor.
Then we'll do it that way. Your request is granted.
Yes, Your Honor. That concludes our housekeeping matters. We have 2 motions in limine to take up before the court as well.
All right, before we get to limines, let me ask if either of the other parties have any housekeeping matters.
Yes, Your Honor. A couple additional things. First, we would ask for constructive sidebars, meaning all objection arguments be heard constructively outside the jury's presence for the purposes of the competition.
All right. Anybody have a problem with that?
No objection, Your Honor.
We have no objection.
Then we'll do it that way. What
And
else?
and lastly, Your Honor, we'd like to ask what your preferences are in terms of asking permission to approach the bench and any witnesses. Would you like us to ask to approach every time, just the first, never ask?
Every time.
Sounds great, Your Honor.
All right. Anything else?
Nothing else, we're ready for motions.
Thank you. Anything of housekeeping nature from Sterling?
Yes, Your Honor, 2 additional matters. First off, for the expert witnesses in today's case, would you prefer that we formally tender those experts or just lay the foundation?
I prefer that you tender them. I don't expect that there are going to be objections as to their qualifications, but I think it's better in the record if you tender them.
Understood, Your Honor. And lastly, what are Your Honor's preferences for publishing exhibits to the jury? Once an exhibit has been admitted into evidence, are we free to publish it to the jury?
Yes, but it depends on what you mean by publishing. I don't necessarily want lawyers walking over to the jury box and passing pages up and down through the members of the jury. We don't have an overhead projector here with a screen where you can do it easily. Let's just say this, if you wish to formally and physically publish an exhibit to the jury, you need to ask leave and then explain to me what you propose to do, and we'll take it up on an ad hoc basis.
Understood, Your Honor. With that,
Okay.
we're also ready for substantive motions.
All right, I'll turn back to the plaintiff. What substantive or motions in limine, what other matters do you have?
Yes, Your Honor. Our first motion concerns Exhibit 49. Would Your Honor like a copy?
Yes, please, if you'll approach. Thank you.
Yes, Your Honor. Now, Exhibit 49 is an email that was sent from Mr. Draper to his attorney at the time, and this was produced inadvertently during the discovery process for this case. And our motion is to exclude this document under attorney-client privilege. Now, this case was brought pursuant to 28 United States Code Section 1332 under diversity of citizenship jurisdiction. And the relevant standard here that Texas follows comes from Ryan Law Firm versus New York Marine, which explained that the state of Texas and federal courts in Texas apply Texas substantive law when it comes to applying attorney-client privilege in diversity cases. And in this case, the standard to apply, as set by the Fifth Circuit and also followed by the state of Texas, United States versus Robinson, explains that whereas the reasonable expectation of privacy for the individual who inadvertently discloses a piece of evidence, where that reasonable expectation of privacy exists, attorney-client privilege is not waived, even though there is an inadvertent disclosure, and that's what occurred in this case. This was a disclosure inadvertently from Mr. Draper's email. Mr. Draper did not have, no one else had actual access to this email that Mr. Draper was using. It was inadvertently disclosed. He expected privacy for the email, and the privilege should be invoked.
All right, what responsive argument do I have from the defendants?
Yes, Your Honor, for Waco National?
Yes.
Your Honor, we would oppose this motion. Your Honor, this email does not qualify as privileged because it was disclosed, but additionally because the plaintiff did not have that expectation of privacy. Your Honor, under case law Willis v. Willis, it provided an example with very similar circumstances. In this instance, because the plaintiff asserting privilege has the burden to prove they had that expectation of privacy and that expectation was reasonable. Well, in Willis v. Willis, when the children had the email password to a parent's email, the court found that was enough to forego the expectation of privacy. Your Honor, giving out the email password to other people, that's enough to forego that. You've now waived disclosure. In this instance, the plaintiff has given out that email password to 3 people.
Does it matter if those people are close family members or third-party strangers?
Your Honor, under Willis v. Willis, it actually doesn't. In Willis v. Willis, it was the own children of one of the parties, of actually both parties. But it didn't matter that they were their children. It mattered that they were third parties. Your Honor, it doesn't matter that it's exactly that whether or not they're families. It's focused on if there is a third party. But additionally, Your Honor, they disclose this not only to their children, but also their spouse. So any argument that the children were minors or anything like that, well, that's not present here because they also gave it to their spouse.
All right. Does Sterling family have a position on this?
Your Honor, Sterling Family Nursery does not intend to elicit this testimony from the plaintiff. Therefore, we have no objection to plaintiff's motion.
All right. Anything in rebuttal from plaintiff before we move on?
Yes, Your Honor. Waco National Golf Club's interpretation of Willis versus Willis is incorrect. What the court explained in Willis versus Willis is that there is a distinction between actual use of a device and simply sharing a password with another individual. And Willis versus Willis, both of those factors were met. A password was shared with a family member, and there was actual use by the family member. Both of those were used to then waive attorney-client privilege. In this case, we have disclosure of a password to Mr. Draper's family member, but we do not have actual use by the family members. Both of those are required to waive attorney-client privilege, and both of those requirements are not met.
All right. I'm persuaded that the plaintiff has the better part of this argument. I don't find that there's a waiver of attorney-client privilege. I'm going to exclude Exhibit 49. What's next?
Yes, Your Honor, our next motion concerns Exhibit 9. Would the court like a copy?
Yes,
May I approach?
please do. Thank you.
Thank you. Exhibit 9 is a receipt belonging to Mr. Casey Draper that he received on April 8th of 2022 when he was at the Waco National Golf Club property. And this is a receipt for purchase of several food items and for alcohol. And in this case, neither defendant has alleged any contributory negligence on the part of Mr. Draper and have not alleged that any alcohol consumption contributed to proximate cause in any sense of the word. And for that reason, our motion is to exclude this under Rule 401 as irrelevant and under Rule 403 as more prejudicial than probative. And after speaking with opposing counsel before trial, both have stipulated to excluding this document.
So you're telling me opposing counsel joined you in asking that this be excluded?
Yes, Your Honor.
Then we don't have anything to argue about, do we?
No, Your Honor.
Then it's excluded.
Yes, Your Honor.
What else do you have?
That concludes our substantive motions. We're ready for opening statements.
All right. What potential pretrial matters does Waco National have?
Your Honor, we have one substantive motion. We
Okay.
move to exclude any evidence or argument of a prior unrelated accident, specifically of an incident in 2002 where a tree branch on Waco National Golf Course, it broke and it hurt someone. Your Honor, we move to exclude that evidence as irrelevant under 401 and more prejudicial than probative, substantially so under 403. Specifically, Your Honor, when attorneys attempt to use this as any sort of notice, when they try to provide notice use from a prior bad incident, well, Your Honor, they have to show that they're substantially similar enough. They have to show that the incident in 2002 and the incident in 2022 had substantial similarities, substantial enough to give Waco National notice that their trees were at risk of injuring people. In this instance, they won't be able to meet that burden because in 2002, it was one tree branch. In 2002, it was 50-mile-an-hour winds. In 2022, 20 years later, it was an entire tree uprooted with the root system. In 2022, it was only 25-mile-an-hour winds. Your Honor, there's a distinction between those two and substantial enough to not provide notice to Waco National. It should be excluded.
All right. What's the plaintiff say in response?
Your Honor, we oppose this motion. The relevant standard that the Fifth Circuit follows here comes from North American Van Lines versus Amons. And what that standard explains is that past accidents of a similar type, which a party should have guarded against, are admissible to show knowledge on the part of that party. And that's what this evidence would be used for here. Now, going to what opposing counsel stated about the incidents being required to be substantially similar, that's not the law. In fact, what Columbia Medical Center versus Meyer holds is that an unrelated incident may be offered to show knowledge if it occurred under a reasonably similar circumstance. And both of the incidents here, while unrelated and the drasticness of damage, did occur under similar circumstances. Both involved trees, both involved wind, Both involved areas of the trees dropping to the ground and injuring a person.
What difference does it make that one event's 20 years in the past versus 2022? I mean, it would seem that something in distant proximity time-wise as opposed to something of a recent occurrence might figure into determining whether these are substantially similar. What's your position on the chronology, the time passage here?
Yes, Your Honor, there's no bright line rule in the Fifth Circuit or the Texas federal courts follow in determining the length of time that must pass between when one incident occurred and the following incident occurred. And in this case, what's relevant isn't necessarily the time, but it's the similarity of circumstances in which both events took place. That's what's relevant to show knowledge.
All right. Does Sterling family have a position on this matter?
Yes, Your Honor. Sterling Family Nursery would join with the plaintiff in opposing Waco National's motion. Your Honor, the relevance of this prior incident is to show a failure on behalf of Waco National to reasonably warn their guests about a potential risk, which is directly at issue in this case. Your Honor, in relevant case, Nissan Motor Company v. Armstrong, which was decided in the Supreme Court of Texas on March 3rd, 2004, and can be found in 145 Southwest 3rd, 131, the court found that evidence of dissimilar defects in a product defects case were admissible because it suggested that something could happen and that it did occur, and yet the defendant failed to take steps to warn people about those potential defects. Your Honor, even though we have some distinguished facts here, it is a naturally occurring tree that a tree branch fell off of in 2002, whereas here we have a newly planted tree that entirely fell over. What is similar is that these were trees on the defendant's property, trees that could have injured people who went to the defendant's property to look at a golf tournament. And in both instances, we allege that it was negligent of Waco National to fail to warn their guests about these potential risks. That's what makes that prior incident relevant, and that's why we oppose Waco National's motion.
All right. With regard to the prior similar accident issue and the tree branch from 2002, I'm going to exclude that evidence. We're going to try this case, counsel, based on these facts and not something that happened 20 years ago. There's enough difference here that, in my view, the potential prejudice to the jury far exceeds fairly limited probative value. This is out.
Yes, Your Honor.
All right. Does Waco National have anything else of a pretrial nature?
No, Your Honor, we're ready for open.
All right. I'll turn then to Sterling Nurseries, Sterling family. Do you have any pretrial issues to raise with the court?
Yes, Your Honor. Sterling Family Nursery has one motion. We move to exclude Exhibit 51 or any reference to it from this case. Your Honor, we have an entire record of all of the depositions and exhibits in this case. We've shown this to both opposing counsel before trial. May I approach for the court's convenience?
Is this Exhibit 51?
It's the entire case file, Your Honor, but we can turn it to Exhibit 51 for your convenience.
If you're targeting your objection to Exhibit 51, that's what I want to see.
Absolutely, Your Honor.
Please approach with that when you're ready. Thank you.
Yes, Your Honor. For some additional context, this is a document that was from a month after this incident in question, in which Lane Harris, who is the head arborist for the Sterling Family Nursery, was given a warning or a reprimand from a supervisor at the Sterling Family Nursery. We move to exclude this evidence as it is inadmissible as a subsequent remedial measure under Rule 407 of the Federal Rules of Evidence. Your Honor, in relevant case, Hannon v. Crete Carrier Corporation, which was decided in the United States Court of Appeals for the Fifth Circuit on June 17, 2022, which can be found at 2022 U.S. Appeals, Lexus 16895, the court found that a written warning from after an incident was not admissible, specifically because of the type of chilling effect that admitting this kind of evidence can have. Your Honor, the entire purpose of Rule 407 is to not allow subsequent remedial measures as proof of negligence on behalf of any party. And Your Honor, in this case, using a reprimand from after this incident to show that Sterling Family Nursery was negligent in any way would be exactly what Rule 407 is intending to prohibit.
All right. What's Waco National's position on this?
Your Honor, Waco National, I apologize, I want to make sure that's on. Waco National opposes this motion. Your Honor, we oppose this motion first and foremost because we're fine redacting the portions which we believe are concerned with 407. Everything from action taken as a result of this instance and down. We're fine with leaving only the parts up to and including the fall on April 8th. We're fine with redacting about 2/3 of the document, Your Honor, the part that talks about the written warning, that talks about Harris will receive a written warning notice. We're fine redacting those, Your Honor, and I believe that quells the issue of 407.
What's the probative value of the portion that you're urging the court to admit without redaction?
Yes, Your Honor, these are statements by a party opponent employee, specifically the supervisor named Augusta Jones, the supervisor at Sterling Family Nursery, who stated, Lane Harris inspected the course and trees on that course, including the subject trees, and should have warned Waco National about the wet and soggy conditions. Your Honor, it's highly probative that their own employee concluded they should have warned Waco National.
All right. What's plaintiff's view on this issue?
Your Honor, we agree with Sterling Family Nursery that this document should be excluded as substantive evidence. However, it should not be excluded for impeachment evidence. And the case on point here is Associated Terminals of St. Bernard versus Potential Shipping HK. And what that case explains is that even where Rule 407 applies, even where a document like this, a warning, should be excluded for substantive evidence, it may still be included as impeachment evidence and used over the course of trial should impeachment become necessary.
Do you anticipate Augusta Jones to testify in this case?
No, Your Honor, we don't, but we do anticipate Dr. Harris, who's the subject of that warning, to testify.
How are you going to impeach Mr. Harris with a statement that came from Augusta Jones? It's a prior inconsistent statement that serves as the basis for any impeachment, whether it's a memo, a deposition, or any document. It's got to come from the person that made the prior inconsistent statement. If Augusta Jones is not going to testify, you're not going to impeach some other person, even if it's the person that's addressed to, with this being a prior inconsistent statement. I'm going to exclude this document. I don't think it's admissible. That is Exhibit 51.
Yes,
Thank
Your
you,
Honor.
counsel.
Yes, Your Honor.
All right, are we ready to proceed with the opening statements from the parties? Anything else?
Ready for openings, Your Honor.
All right, have a seat, counsel. Let me hear from plaintiff. You may proceed with your opening statement.
Yes, Your Honor. Before proceeding, may I publish Exhibit 11 to the members of the jury? We have a good faith basis to believe that this will be admitted over the course of the trial. It's a video showing what occurred at the golf course on April 8th.
You can present it as a part of your opening.
Yes, Your Honor. And may I proceed?
You may proceed, counsel.
May it please the court, opposing counsel, members of the jury. It's April 8th, 2022 at the Waco National Golf Club. It's the Legends Golf Tournament. And it's about 4:30 p.m. We're on the 16th hole. Professional golfers are finishing up their putts on the green. Hundreds of spectators are watching. When off in the distance, this happens. Now, members of the jury, what you don't see in that video, the person who you don't see being crushed by that tree, is this man right here. This is Casey Draper. And on April 8th of 2022, what was supposed to be a day that was made of his dreams became his worst nightmare. Casey Draper, the evidence is going to show, was crushed by a 100-foot tall pine tree at the Waco National Golf Club. And you're going to see that as a result, he's paraplegic now. His back was broken. His spine was snapped. His legs went numb forever. And that's why we're here today. Because we, the plaintiff, have brought this case. We brought a claim of negligence against the defendants. Because it was their responsibility to keep Mr. Draper safe. It was their responsibility to prevent this, and the evidence is going to show that they failed. Now, because we've brought this claim, because we've alleged that the Waco National Golf Club and that the Sterling Family Nursery were negligent in this case, we have to prove to you that they were negligent. And here's how we're going to do it. First, with Waco National, we're going to show you that they had a duty. Waco National had a duty to keep the visitors at their golf course safe. They had a duty to keep Mr. Draper safe. And you're going to see through the evidence that Waco National breached that duty. Waco National created a dangerous risk on this course that a tree would fall. And what the evidence is going to show is that Waco National knew about the risks. They knew that the conditions on this course were ripe for a tree to collapse. They knew that the conditions on this course were ripe for a tree to fall on one of their visitors. But they ignored it. And as a result, the tree fell and Casey Draper was paralyzed. Now, we haven't only sued the Waco National Golf Course in this case. We've also sued the Sterling Family Nursery, who provided the trees on the Waco National Golf Club. And what we're going to show with the Sterling Family Nursery is that they had a duty to safely install those trees. Now, what you're going to see over the course of this trial is that the trees on the Waco National Golf Club, they weren't born there. They didn't grow there. They were transplanted. The Waco National Golf Club, the defendants, decided to make their course look as best as it possibly could, that they were going to transplant 100-foot tall pine trees right into the golf course overnight. And to do that, they hired the Sterling Family Nursery. And when the Sterling Family Nursery came out and installed those trees, they owed a duty to do it safely. And the evidence will show they breached that duty. And they breached that duty when they did exactly what Waco National told them to do. The evidence is going to show that when the Sterling family went to install these trees, when they went to plant these trees into the ground, they told Waco National that there were safety concerns. They told Waco National that they needed to stabilize these trees so that the trees would have time to have their roots develop, so they'd have time to stabilize on their own. But Waco National refused. And in response to that, you're going to see that Sterling Family Nursery went right along with it. Sterling Family Nursery went right along with ignoring safety, went right along with ignoring the standards that were required. And again, as a result, you're going to see that the tree fell. Now, the origin of all of this, the reason ultimately why we're here today, started over 20 years ago. Because you see, if we move back to 2001 at the Legends Tournament, one of the best golf tournaments in the world, that's the origin of why Waco National planted those trees. Because in 2001, a professional golfer named Puma Jones, who was something of the likes of Tiger Woods or Arnold Palmer, made Waco National look like child's play. Waco National, which prides itself on being one of the hardest golf courses in the world, which prides itself on its beauty, which prides itself on being so competitive, the evidence is going to show that Puma Jones made it look like a putt-putt course. And because he did that, Waco National decided that major changes were needed. You're going to see that they lengthened the course, that they added more obstacles, that they added, most importantly, trees. And to install those trees, that's when they came to meet the Sterling Family Nursery. Now, over the course of this trial, we're going to show you how both of the defendants breached their duties, how both of those defendants caused the injuries to Mr. Draper in 3 ways. First, we're going to show you that it was Waco National Golf Club's course. You're going to see that Waco National controlled this golf course. You're going to see that they controlled everything that happened on this course. They controlled where their fans could go. They controlled where the fans could sit, where they could stand. Everything about this course, Waco National controlled. And they loved it. You're going to see that Waco National took so much pride in this course that that pride became arrogance. And members of the jury pride cometh before the fall. You're going to see that in maintaining this course, instead of choosing safety, Waco National chose profit. They chose to focus all of their efforts into creating this tournament, all of their efforts into creating a golf course that would look good for the TV cameras, that would look good for the news. And in doing so, they ignored safety. Now that brings us to the next point. It was the defendants' choices. Now, there are choices made by both Waco National and by the Sterling Family Nursery. You're going to see that Waco National chose to install those trees knowing the safety risks. And in April of 2022, you're going to see that Waco National chose to hold a tournament and have fans at their course knowing that their trees were at risk of falling. Now you're going to hear from one of the inspectors, one of the Sterling Family Nursery's representatives who actually went out to the course before the tournament and did an inspection of all the trees. And this inspector is going to tell you that the trees were at risk. He's going to tell you that he informed Waco National about these problems. But Waco National chose to ignore it. And then on the day of the competition itself, you're going to hear about the weather. You're going to hear how the conditions that day became ripe for a tree to collapse. You're going to hear about the rain, about the wind, about the storms moving in. And you're going to hear that instead of calling off the tournament, instead of ushering all of their visitors to safety, Waco National said to keep going. Waco National told their fans to stay out into the trees and to keep the tournament rolling so the cameras would keep showing their course. Members of the jury, that is negligence. Now, it's not only the choices of Waco National that led to this injury, it's also the choices of the Sterling Family Nursery. And what the evidence is going to show, that the Sterling Family Nursery chose to go along with whatever Waco National told them to do. When Waco National told them to put a tree in the ground without any support, the Sterling Family Nursery went right along with it. The Sterling Family Nursery chose not to inform Waco National of other ways that they could secure their trees. They chose to ignore the risks as well. And finally, that brings us to the third point, collaboration. The evidence will show that over a 25-year period, Waco National and the Sterling Family Nursery worked hand in hand. Waco National would call up the Sterling Family Nursery and ask them to go plant some trees in their course, plant those trees without any safety, plant those trees without any stabilization, and the evidence will show that Sterling Family Nursery went right along with it. You're going to see that they worked together in ignoring the risks, they worked together in ignoring the dangers. And as a result, Mr. Draper is never going to walk again. Now, members of the jury, at the end of this trial, we're going to come before you again. We're going to walk you through the evidence. And over the course of this trial, you're going to see that the liability of these defendants, it's not at issue. The liability of these defendants is going to be proved quickly for you. You're going to see that that's not the issue in this case. What is the issue is who is more at fault. And you're going to see that the Waco National Golf Club is most at fault here. That even though the Sterling Family Nursery was negligent, that Waco National Golf Club is the contributing and primary contributing factor to injuring Mr. Draper. And that is why that we're going to ask that you find both of the defendants liable. Thank you.
Waco National may now present its opening statement.
Thank you, Your Honor. And do we have the court's permission to display Exhibit 8 on the screen to the jury? We have a good faith basis to believe it will come in during trial, as well as we've informed both opposing counsels.
Is there objection from either other party?
No objection, Your Honor.
All right, permission's granted.
Thank you, Your Honor.
Proceed
And
with
may it
your
please the court.
proceed with your opening statement.
They entrusted the experts. It's March 31st, 2022. Dr. Lane Harris is standing on putting green at the Waco National Golf Course. But Dr. Harris doesn't work for the golf course. He works with trees for a living. He has a PhD in forestry. He's an expert. As he walks the course, he sees the dozens of trees that he planted. Trees he was hired to inspect. So he gets to work, meticulously reviewing the trees, looking at their roots, their branches, their leaves. When he gets back to the office, types up his report. There are no issues with your trees. There are no major safety concerns. He signs his name, sends it off to the head groundskeeper. Members of the jury, we now know that just a week later, one of those trees came down and hurt someone. And what happened to Mr. Draper that day was awful. And it wasn't his fault. He didn't know those trees were dangerous. He didn't know that tree might come down. He didn't know it had received a passing inspection grade when maybe it shouldn't have. But the evidence will show neither did Waco National Golf Club. The evidence will show there was only one mistake made in this case. The expert's mistake. The mistake of the Sterling Family Nursery. And Waco National, they just relied on the experts. They entrusted their experts. As the plaintiff, they brought this suit, and they have the burden. They have the burden to prove Waco National was negligent. But they'll fail to meet their burden today because of 3 reasons. Reason 1, the experts installed the trees. Members of the jury, today you're going to get to meet Rory Campbell. Mr. Campbell works at the golf course. He knows a lot about golf. There's not a lot about trees. So back in '97, when Waco National was looking to plant some new trees, he called up Sterling Family Nursery. He called the tree experts. Now, Sterling Family Nursery, it's not the nursery you might be thinking of. They don't work with babies. They work with trees. This is the 17th hole at Waco National. This is where the accident occurred on April 8th. Today, it'll be undisputed. Every single new tree at Waco National was inserted by Sterling Family Nursery. It was installed by them. That includes the new trees at the 17th hole. And that includes the tree that injured the plaintiff. Brings us to reason 2. The experts inspected the trees. Today, you're going to learn that after they had the trees installed, Waco National hired the Sterling Family Nursery to inspect the trees, to make sure they were safe. So Sterling Family Nursery came out, and they inspected those trees every single year. And in 2022, just 4 days before the accident, Dr. Harris inspected the property personally. That brings us to the third reason. The experts didn't notify Waco of any issues with any trees. Members of the jury, you're going to learn that they inspected those trees every single year. Every branch, every root, every tree. But they didn't find a single issue any of those years. Not in 2021, not in 2022, not ever. The plaintiff just told you. They told you that Waco National made a choice. They said it was their choices that caused this accident. Their choice to not cable their trees. Now, they brought up the recommendation Waco National received to cable the trees, but they didn't tell you when that recommendation was from. Well, it was from 1997. I'm going to say that again. The plaintiff's smoking gun saying Waco National made a choice to ignore a recommendation, that recommendation was from 25 years ago. And you're going to learn, well, Sterling Family Nursery, when they came out and inspected, they never brought cabling up again. And when Waco National declined using the cables, the Sterling Family Nursery installed the trees anyway. They said it was understandable. Members of the jury, in their opening statement, the plaintiff just showed you that box that said what were the responsibilities, what were their duties, and how did they breach them. And I noticed something the plaintiff, they said the responsibility, the duty of the Sterling Family Nursery, well, their duties was to install the trees. Members of the jury, that wasn't their only duty in this case. They not only installed the trees, but they inspected them too. And you're going to see, when they inspected the trees, they told Waco National, you're A-OK. Now it's true. The tree that came down, it was on Waco's golf course. The people sitting under that tree, they were Waco National's patrons. But they wouldn't have let the people sit under there if they knew the tree was dangerous. They didn't know because their experts never told them. And they entrusted their experts to install the trees correctly, to inspect the trees correctly. They entrusted their experts with their guest safety. At the end of this trial, I'm going to come back up here. I'm going to ask you to find Waco National not liable, and instead hold Sterling Family Nursery responsible. Because Waco National, they entrusted their expert. Thank you. Thank you, Your Honor.
All right. Sterling Family Nurseries may now present its opening statement.
Yes, Your Honor. It's 1997, and the Waco National Golf Club decides that their course needs some trees. And you'll find out that they make that decision because the golf club has a reputation to uphold. You see, Waco National has been around for decades. They're the host of one of the most prestigious golf tournaments in the world, called the Legends Golf Tournament. You'll find out that people compete with each other to win tickets for this event in a lottery. So they have a chance to go to Waco and watch some of the sport's greatest to ever do it compete against one another. But it's not just the sport that brings people to Waco for that tournament. It's also the course itself. Which you can see right here in Exhibit 8. With its vibrant green grass, blooming azalea flowers, and of course, those luscious pine trees. Members of the jury, it's absolutely true. The Sterling Family Nursery was the company that installed the trees on Waco National's property. But what's important to remember here is that we're all expected to do different things based on the position that we're in. So far, from the couple of attorneys you've heard from, no one would have dared to place the blame for what happened to Mr. Draper on Mr. Draper himself. No one would have expected Mr. Draper to walk onto that golf course, take a seat right next to the tee box, and expect that a tree would come hurtling down on him. That's not reasonable. But in the same way that it wasn't reasonable for Mr. Draper to expect this to happen to him, you'll learn that it's not reasonable to expect the tree nursery to care more about the golf course's guests than the golf course itself. Folks, today we're going to show you that the golf course wanted all of the control and none of the consequences. You see, as Judge Gilstrap will instruct you, the plaintiff brought a claim of negligence against both the Waco National Golf Club and the Sterling Family Nursery. When they made that decision, they took on a burden to prove this negligence by what's called a preponderance of the evidence. But Judge Gilstrap is also going to tell you that what it really means to be negligent is failing to use ordinary care. Ordinary care meaning what a reasonable person or a corporation, whatever it is, in the same circumstances would do in the same situation. And today, we're going to ask you to apply that standard to everyone. Of course, to Mr. Draper. Of course, to the nursery. And of course, to the golf course. Today, we're going to show you that it was the golf course that was responsible for keeping people like Mr. Draper safe. And we'll show that to you by establishing two things. First, that the tree nursery acted reasonably in advising Waco National on what to do with those trees. And second, that Waco National failed to act reasonably when it came to keeping their guests safe. So let's start by taking a look at the first thing the evidence will show, which is that the tree nursery acted reasonably in advising Waco National on what to do with those trees. Now, opposing counsel is absolutely right. To really understand what happened in this case, we've got to go back to 1997. And you're actually going to get to see a letter from 1997 later today, right here. You can see in the second paragraph, written by Lane Harris, the head arborist at the tree nursery. I noted that none of the newly planted trees at the golf course are cabled to the ground, which we would think of as standard procedure with a newly planted tree until that tree has been in the ground for 8 to 10 years and had a chance to develop a stronger root system. That's what the nursery made sure to tell Waco National at the very beginning of this relationship that existed between them. But today you'll find out how Waco National responded to that. According to them, according to Rory Campbell, the head groundskeeper, cabling those trees was a complete non-starter. There's no way that this prestigious golf tournament could install cables on their trees. It'd make the place look terrible. It would make it impossible to play golf. But folks, what you've got to remember is that while the tree nursery planted those trees, when it came to where they were planted, that was the golf course. When it came to when they were planted, that was the golf course. When it came to how they were planted, that was the golf course. And if you take a look again at that exhibit, Exhibit 8, you'll find out that it was the golf course, and only the golf course, that made the decision to invite spectators onto their property and seat them underneath those trees that they chose to install without cabling, that they chose to install in a way that would make them less safe. And that's what brings me to the second thing the evidence will show, which is that Waco National failed to act reasonably in protecting their guests. You see, members of the jury, it's absolutely right. Every single year, Dr. Lane Harris, the head arborist at the tree nursery, would go onto the property of the golf club and walk around with Rory Campbell to look at all the trees on the property. They would go through together and inspect them, and Rory Campbell, the head groundskeeper for Waco National, would go with Dr. Harris on these trips. You see, the two of them have had this relationship for decades now. They're good friends. And on these walks, Dr. Harris would let Mr. Campbell know about some of the risks on that golf course. You'll find out that just a week before the tournament that the golf course hosted, Dr. Harris made sure to tell Mr. Campbell that golf course was a little too wet. And because it was so wet, it made those trees that the nursery installed on the property unsafe. But you'll find out that after hearing that, Mr. Campbell didn't let the course dry up a little bit. He didn't decide that maybe the tournament should be pushed back. You'll find out that Mr. Campbell, after hearing that the course was too wet, decided to water it every day, twice a day for 45 minutes, every single day leading up to finally, when that tree fell on Mr. Draper. Why? Because again, he wanted the course to be more beautiful. You'll learn that that was the golf course's priority. They wanted all of the control. And now that we're in this courtroom and Mr. Draper's life was changed in an instant, they don't want any of the consequences. Folks, just now you heard from plaintiff's counsel that Waco National Golf Club's course, they're the ones who controlled it. They controlled everything that happened there. You also heard from Waco National's attorney that the experts were the ones who installed the trees, and that's true. But the golf course chose when to plant them, where to plant them, and how to plant them. That's why at the end of this case, when I get a chance to get back up here and deliver a closing argument, I'm going to ask that you return the only reasonable verdict in this case. A verdict that holds the party responsible for this horrific injury that was in the best position to stop it from happening. I'm going to ask that you find the Waco National Golf Club liable.
All right, we'll proceed with the plaintiff's case in chief. Counsel, call your first witness.
Yes, Your Honor, at this time, the plaintiff calls Mr. Casey Draper to the stand.
All right.
Is that okay, Mr. Draper?
All right, counsel, you may proceed with direct examination.
Good afternoon. Could you please introduce yourself?
Sure. Good afternoon, everyone. My name is Casey Draper.
And Mr. Draper, what do you do for a living?
Currently, right now, I own my own construction company, WBC. You may have seen it. We build construction.
Well, tell us about your life outside of your construction company.
Sure. I live currently in Durant, Oklahoma. For those of you, it's right on the border of Texas. It's about 30 minutes north of Sherman, Texas. Have you ever heard of that? I live there with my wife and my 2 kids, and yeah, I do pretty much everything with them, everything that I can do.
Well, outside of running your business and spending time with your family, do you have any hobbies?
Well, I love golf. I love watching it, and I used to love to play it. I played in high school, college. It's kind of a big part of my life.
And over the course of time in which you played golf, had you ever heard of something called the Waco National Golf Club?
Absolutely. They're a club here in Waco, Texas that owns and manages one of the golf courses, but more importantly, hosts one of the biggest tournaments in the world, the Legends.
Well, we'll talk about the Legends Tournament in just a second, but for now, tell us more about Waco National.
Sure. So Waco National, like I said, they operate here in Waco, Texas. They have a course, but not everyone can just go to it. You have to be a member of a club to be able to, actually get on the course if, it's not the week of the Legends.
And you said the Legends Golf Tournament. What's that?
Sure. So that's one of the big 4 golf tournaments in the country. You have pros come all over to come play. It's an awesome tournament that you just get to see the best in the world compete. I think it's the best one out of the 4, but I'm probably just a little biased. So yeah.
And Mr. Draper, can just anybody go out to the Legends Golf Tournament?
No. There's actually like a lottery system in order to get a ticket. So I've signed up for the past couple years, my friends and I, so we can get a seat. And in 2022, we were lucky enough to get tickets.
Well, let's talk a little bit about the 2022 Legends Golf Tournament. So walk us through, how did that day start for you when you got to Waco National?
Sure. So Friday was round 2. And so the doors opened at 8 a.m., but I wanted to get what I thought was the best seat that I thought everybody would be competing. So I got there with my buddies at like 6:30 in the morning, just so we could be there where we wanted to be at hole 17.
And why'd you pick hole 17?
So hole 17 has a beautiful view of where the tee box is. You can see everybody driving. It's a par 4 course. And again, like I said, I think it's the best way to see all of the pros. It's a beautiful view of the players, the drives. Like I said, I think everybody was kind of fighting to get there.
I want to talk a little bit more about the layout of hole 17 and what you saw while you were there. Approaching opposing counsel, what's been marked as Exhibit 6 and Exhibit 7. And Your Honor, may I approach the witness?
Yes.
Thank you.
Mr. Draper, I just handed you what's been marked as Exhibit 6 and Exhibit 7. Could you tell us what those are?
Sure. This is kind of, I guess, an aerial layout of hole 17.
And are you familiar with that layout?
I am. Yes, sir.
Has that been changed or altered since you last saw it?
Not that I can tell. No.
Your Honor, at this time, plaintiff moves Exhibit 6 and Exhibit 7 into evidence.
Are there objections?
No, Your Honor.
No objection.
They'll be admitted.
Your Honor, may we publish?
Yes. How do you propose to publish them, counsel?
We have the trial pad screen right here, which
That'll be fine.
it should pop up. Now, Mr. Draper, could you tell us what we're looking at here in Exhibit 6?
Sure. So that's the aerial view of hole 17. Again, the one that I was able to get a seat at.
Now, what are those light green rectangular boxes down at the bottom of that image?
Yeah, so the bottom there, those are the tee boxes. Essentially, that's where the players go, and that's where they tee off. So that's where we wanted to get the best view around that area.
And what are all those dark green splotches around that map?
Those are the trees. That's kind of another thing about hole 17, the aesthetics. There's trees everywhere and around the tee boxes.
Let's talk about where you were sitting. So let's look at Exhibit 7.
Yeah.
And could you tell us what the red X is in Exhibit 7? I believe you have the paper copy in front of you.
Sure,
We'll get it up on the screen in a second.
Sure. So I actually marked where I was sitting. Me and my buddies, like I said, we got there early so we could get that. And so we were sitting right next to the tee box, but again, also right in between where those trees were.
And like you said, on Exhibit 7, that area where you're sitting, that red X, were you underneath any trees there?
Yeah, like directly underneath trees. That's where the rope was, and that was the closest that we could get.
And if you want to be seated at that tee box on hole 17, do you have to be close to a tree at all?
Yes, in fact, you have to be kind of right next to them. That's where we ultimately were.
Now, you mentioned a rope holding off the tee a moment ago. Let's talk about what that looked like. Approaching opposing counsel, that's been marked as Exhibit 8. May I approach?
You may.
Thank you.
Mr. Draper, I've just handed you what's been marked as Exhibit 8. Could you tell us what that is?
Sure. So this is, I guess, a different view of hole 17, but again, this shows you the rope and where we were able to sit.
And has that been changed in any way since you last saw that image?
No, sir?
Plaintiff moves Exhibit 8 into evidence.
Is there objection?
None, Your Honor.
No objection.
Will be admitted.
May we publish?
You may.
Now, walk us through what we see here.
Sure. So as you can see, you have the hole 17, kind of like I said, it's a straight view. There's the trees in the area, but I think most importantly is also where all the spectators are able to sit. You can't just sit on top of the competitor, so the golf club puts rope so that the spectators essentially can have that line between where the players are and where the spectators sit.
And at hole 17, did that rope keep the spectators in the forested areas?
It did. Like I said, pretty much anywhere you wanted to go, there was a tree either to the left, to the right, or right behind you.
But now that you understand what hole 17 looked like while you were sitting there, let's talk a little bit more about the conditions on the course that day. So why don't you tell us, how was the weather?
Yeah, so it wasn't ideal for a golf tournament, but like I said, it was the biggest one. It was skies were gray all day, pretty cloudy, and then as the day went on, we started to see some rain, some wind, things like that.
And did the rain ever get worse over the course of the day?
Yeah, so it started off with just drizzling, I'd say, nothing too bad, but then it started getting pretty heavy. I even heard some thunder.
And at any point, did the golf course stop the tournament?
They did. They stopped the tournament by letting out the sound of an air horn, which tells you essentially that they're delaying. It's not telling you that the day's over, but just as of right now, there's a delay, and you kind of just have to wait and hope that the game will start back up soon.
And when you hear that air horn, like you said that you heard that afternoon, does that mean that you have to evacuate the course?
No, there's a different kind of signal for that. Air horn's just to tell us that the play is going to be delayed for a bit, which you can assume is because of the weather.
And you said that there's a different noise that they play for when you actually have to evacuate. What kind of noise is that?
Yeah, so that's a siren. It's much louder, again, much a bigger deal because it tells you you need to evacuate, you need to get all your things and go find shelter, essentially.
And when you were sitting out there during this weather delay, did anyone from Waco National tell you that you needed to go indoors?
No, in fact, the opposite. They said I'd probably be fine where I was.
Did anyone from Waco National tell you that you needed to get away from the trees?
Not a single person, no.
And you said that there was a weather delay in play. So what time did play start back?
So it started back up at around 3 p.m., I think, around there. It went on for about half an hour, and unfortunately then a second time there was a delay.
And tell us about the conditions before that delay.
So the second time it was a little bit different. At this point the wind started picking up, and it was pretty drastic, much severe than it was earlier in that day. And so things started flying at the course, and I thought we were probably going to get a second delay pretty soon.
And did that delay follow quickly after that?
It did. That's right.
And during that second delay, did you ever hear a siren when they announced that the course was going to be delaying play?
Not at that point. The siren didn't come until later.
And tell us what happened shortly after the golf course delayed the tournament.
So that was when the tree fell. Essentially, I heard a noise that just sounded like different cracking. I looked up. I started hearing people yelling, "Move, move, get out." And I got up to try to move because I saw the tree coming down. And I tripped, and I fell, and the tree fell right on me. I could hear my back crack, and I was just there in shock the entire time.
Mr. Draper, I know this is extremely difficult to talk about, so if you never need to take a second, please just let me know.
Thank you.
But can you tell us what kind of injury you suffered after this tree fell on your back?
Sure. The doctors told me that I would never be able to walk again. Now, paraplegic. That was pretty much it.
And Your Honor, at this time, I would ask to show Mr. Draper outside of the eye shot of the jury what's been pre-marked as Exhibit 11 for him to verify what it is, just out of the constructive eye shot, if I may.
Is there objection?
No, Your Honor.
No objection.
All right, you may proceed.
Now, if you could pause, please. Could you please tell us what we're looking at here?
Yeah, that's the end of hole 16. You can see that angle, but that's over there where the tree is, where the tree fell, what I was just talking about.
Are you familiar with this video?
I am. Yes, I've seen it before.
Your Honor, plaintiff moves Exhibit 11 into evidence.
Any objections?
No, Your Honor.
No objection.
Exhibit 11 is admitted.
And Your Honor, may we publish?
You may.
If you could please restart the video. Now, Mr. Draper, I know this is difficult to watch, but is that you under that tree?
Yeah, you can't see me from that angle, but that's the tree that fell on top of me.
Thank you, Mr. Draper. Your Honor, I have nothing further. Pass the witness. And if I may approach and retrieve the documents.
You may. Waco National, you may cross-examine.
Yes, Your Honor. Good afternoon, Mr. Draper.
Good afternoon.
I'm really sorry about what happened, and I only have a couple of questions to ask you.
Thank you.
The trees you were talking about on direct examination, you don't know who installed them.
No, I didn't know before this litigation ensued. No.
You don't know who inspected them.
No, I don't.
You don't know whether those trees passed inspection.
Yeah, I don't know anything about that.
Pass the witness, Your Honor.
All right. Sterling family, you have cross-examination of this witness.
Yes, Your Honor.
Proceed with cross-examination.
I apologize, Your Honor. My second chair just needed access to the trial pad. Good afternoon, Mr. Draper.
Good afternoon.
I want to start off to you by talking about golf, actually.
Okay.
You would describe yourself as a pretty big fan of golf.
Absolutely.
You've been playing it, or you used to play it, for several years.
Yeah, that's right.
You grew up playing golf.
I did.
You spent your college days playing golf.
I did, yes.
You've been to lots of country clubs.
That's right, yeah, Durant specifically.
And that's exactly why you were excited to attend the Legends golf tournament, right?
Yeah, like I said, I think it's the biggest championship that exists.
That's a tournament that's held by the Waco National Golf Club.
That's right.
You've described this as the most prestigious golf tournament in the world.
I think it is. People may disagree, but it's one of the top four. You can't argue that.
In fact, to get a ticket, you actually had to enter into a lottery.
That's right.
But you've also described it as one of the most beautiful golf tournaments in the world.
I think so.
Your Honor, may we publish Exhibit 8 on the trial pad?
You may.
Looking at this photograph again, Mr. Draper, you can see that vibrant grass in the photo.
That's right.
And you can see those tall pine trees in the photo too.
Yeah, you can.
Just now, on cross-examination, an attorney from the golf course asked you if you knew who installed those trees, right?
Yeah, he asked that.
I want to ask you a few more questions about those trees. Did anybody tell you that you couldn't sit under those trees?
No.
Did anybody tell you that you should be careful around those trees?
No.
Did you see any type of warning signs around those trees?
I mean, no. Like I said, if you were sitting in hole 17, you were near a tree. So, no, not at all.
Mr. Draper, who sold you the ticket for that golf tournament?
That was Waco National.
Who owned that golf course?
Waco National, I mean, as far as I know.
Who failed to tell you anything about those trees at all?
I mean, Waco National didn't, if that's what you're trying to get me to say, they didn't tell me anything about the trees.
Thank you, Mr. Draper. Your Honor, nothing further.
All right. Is there any redirect from the plaintiff?
No redirect, Your Honor, we just asked the witness be excused.
Well, he's the plaintiff in the case. He's going to remain in the courtroom throughout the trial, but he can step down
Yes,
from
Your
the
Honor.
witness stand.
And if I may approach him.
You can assist him. And counsel, if an exhibit's been admitted by the court, then you may publish it on the screen without having to ask for specific leave. If you wish to publish it in some other fashion, then you need to ask for specific leave. Understood?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
All right, call your next witness, please, plaintiff.
Your Honor, at this time, the plaintiff calls Rory Campbell to the stand.
All right. Mr.
And-
Campbell, if you'll come forward.
And Your Honor, while Mr. Campbell is taking the stand, for the court's note, Mr. Campbell is a party representative for the plaintiff, or excuse me, for the defendant for Waco National. And because of this, we asked to treat Mr. Campbell as an adverse witness pursuant to Federal Rule 611C2.
I understand you're calling him adversely. That's your right. All right, if you've already been sworn, Mr. Campbell, please come take the witness stand.
And may I proceed?
You may proceed with direct examination.
Good afternoon. Your name is Rory Campbell,
That's correct.
and you are the head groundskeeper at Waco National Golf Club.
Correct.
You've been the head groundskeeper for about 30 years now,
That is correct.
and you've worked at Waco National for about 60 years.
That is right.
Now, Mr. Campbell, in the scope of your job as head groundskeeper, you manage a large staff that maintains the golf course.
That is correct.
I want to talk about how you do maintain that golf course and some of the changes that you've made while you've been the head groundskeeper. Your Honor, I'm approaching opposing counsel. It's been marked as Exhibits 35 and 38.
You may approach.
And may I approach the witness?
Yes, these have been admitted
No,
previously?
Your Honor, they have not.
Is there objection to the admission of these documents? You're moving their admission?
Not yet. I was about to have the...
All right, proceed with the witness.
Now, Mr. Campbell, I've just handed you Exhibits 35 and 38, right?
Yes, sir.
And those are two diagrams showing hole 17 at Waco National.
Yes, sir.
You're familiar with those diagrams?
Yes, sir.
Haven't been changed or altered since you last saw them?
No, sir.
Your Honor, plaintiff moves Exhibits 35 and 38 into evidence at
Any
this point.
objection?
None, Your Honor.
No objection.
They're admitted.
And if we could publish. Now, we're looking at a side-by-side here of hole 17 at Waco National over the years, right?
Yeah, yes, sir.
Now, this one on the left, Exhibit 35, that's what the hole looked like in around 2001.
That is correct.
And over the course of the past 20 years from 2001, you at the course underwent a large renovation project.
That's correct.
You added a significant number of trees, as we can see on the right in Exhibit 38.
We added some trees.
And when you added those trees, Mr. Campbell, you didn't just plant seeds on the course.
No, of course not.
You didn't plant saplings on the course.
No.
You went out and bought fully grown, mature pine trees.
Yes, sir.
And some of those pine trees were upwards of 100 feet tall.
Yes, sir, I suppose.
And when you went out to go plant those trees, when you went out to go buy those trees, you bought them from the Sterling Family Nursery.
That's correct.
And when you paid the Sterling Family Nursery, you had them transport the tree to the course,
Correct.
and then you had them plant that tree into the ground.
That is correct.
Now, when the Sterling Family Nursery first started their relationship with you, do you remember them recommending stabilizing the trees?
Yes, there was some correspondence, a letter.
They recommended something called cabling.
Yes, sir.
And cabling is just when you tie a tree down to the ground using ropes, right?
Yes.
But Waco National refused to stabilize the trees.
They decided that it was not necessary.
Right, you decided that it was not necessary for Waco National to cable the trees to the ground.
Yes, sir.
And part of the reason that you decided not to do that is that you thought it would take away from the natural beauty of the golf course.
Yes, the course is known for its beauty.
And let's talk a little bit more about the beauty of that golf course. Now, in your opinion, Waco National is the best golf course in the world,
I believe,
and you're proud of that.
of course.
Waco National is one of the most exclusive golf courses in the world.
Correct.
You're proud of this as well.
Correct.
And Waco National hosts the Legends Tournament, one of the best golf tournaments in the world.
Correct.
You're proud of this as well.
Yes.
Mr. Campbell, you're extremely proud of the work that you've done at your course.
Correct.
And your staff, and you included, go to meticulous steps to make sure that everything on this course is just perfect.
Correct. Some things are not within our bailiwick.
Right, but what you do have under your control at that golf course, you make sure that it's perfect in every way possible.
What we are responsible for, yes.
Let's talk about some of the maintenance that you were doing out at that golf course up to the 2022 Legends Tournament. Now, 2022, the spring of that year, was a particularly wet spring for Waco.
It rained a lot.
Right, and in the month before the tournament, in March, you received 15 inches of rain at the golf course.
If that's what the log shows.
And even in April of 2022, when the tournament was held, it kept raining.
Yes, it was raining. It was a rainy spring.
And around that time, the course started becoming waterlogged.
There were,
Objection, Your Honor.
State your objection.
Calls for an improper opinion. May I explain?
Go ahead.
Your Honor, specifically opposing counsel asked this witness, the course became waterlogged. Now, this witness is not an expert. Your Honor, they have not been tendered as an expert in any sort of hydroponics, in any sort of hydromechanics, and would not be able to testify as to what amount of water would equate to a certain amount of waterloggedness, whether that's an amount of rain, what that would equate to given the depth of the soil, all of those things. They aren't an expert, Your Honor.
Response?
Your Honor, you don't need a PhD in hydromechanics or in hydrology to say when grass is waterlogged, and that's all that this is going to show. This is a lay opinion by an individual who works on this golf course every day and is familiar with what water looks like.
I'll overrule the objection. You can take it up on cross-examination, counsel. Let's proceed with direct.
So to say that one more time for the jury, the course was waterlogged up to the tournament.
the course from time to time, as would be the case in a rainy season, had some standing water. Puddles is what I would refer to.
Right, like you just said, the puddles. So let's talk about what those puddles looked like. Approaching opposing counsel, what's been marked as Exhibit 40. May I approach the witness?
You may.
Mr. Campbell, I'm handing you what's been marked as Exhibit 40. Now, that's a photo of your golf club, right?
That is correct.
Hasn't been changed or altered since you last saw it.
No, sir.
Your Honor, plaintiff moves Exhibit 40 into evidence.
Is there objection?
Yes, Your Honor. We would object under 403 as it's substantially more prejudicial than probative and it's misleading. May I explain?
Hand me the exhibit so I can see it, counsel. All right, I'll hear your objection now.
Your Honor, at this point, for opposing counsel to enter this exhibit showing standing water on the golf course without explaining when this photo was taken, where it was taken on the golf course, what hole it was taken at, if it was taken right next to the 17th tee box or taken half a mile away at the 3rd tee. Your Honor, without any of that foundation, it's misleading to the jury and has very little probative value and is therefore barred under 403.
All right. Does Sterling family have any objection to Exhibit 40?
No objection, Your Honor.
You have a response to that objection, plaintiff?
Yes, Your Honor, we've already established that this photo was taken in March of 2022, and we're not using this to show that this is what the course looked like on the day of the accident. What we are using it to show is that Mr. Campbell was aware of the water problems on the course and then getting into the actions that he took in response to knowing these water problems.
Okay. I'm going to overrule the objection and admit Exhibit 40. Waco National can certainly take up the particulars around this photograph on cross-examination.
And Your Honor, may I retrieve?
You may.
And may we publish?
It's already been admitted. You may publish it.
All right, so we're looking at that puddle that you just mentioned on the golf course.
Correct.
And this was in the run-up to the tournament.
Sometime, yes.
Several weeks before the tournament, right?
I'm not sure exactly when. It was a rainy spring.
Right. Now, it kept raining after you took this picture.
I don't want to say that for certain because I'm not sure of the exact date. It was a rainy spring.
All right, well, in this rainy spring, you kept running the sprinklers at Waco National.
We run the sprinklers according to a routine, yes.
Right, and part of that routine is to run the sprinklers for 45 minutes a day.
Yes, correct.
So even though this was a very rainy season, like you just said, every day for 45 minutes, you were watering the course.
Yes, we like to keep things green.
Right, and you do that, you water the course so much to keep the grass a luscious green color.
To keep it looking very attractive, yes.
You do it so that the azaleas will be in full bloom when the TV cameras come to town.
We do it to benefit the vegetation.
And you also do it so the course will meet everyone's expectations who see it.
Well, we do it because we're proud of the course.
Exactly. Well, let's talk about what happened on April 8th of 2022. Now, it started raining that day as well.
Correct.
And eventually you made the decision to suspend play at the tournament.
The decision is made by the tournament committee, by the PGA rep, and by myself. It's a group decision.
Right, and you were part of that decision.
Yes, as I indicated.
Now, when the decision was made to suspend play, you had access to the weather.
Yes,
You had access to a weather radar,
correct.
and you knew that there was a front moving in.
We saw that the weather was bad, yes.
And you knew that poor weather was moving into town.
Yes, it was raining.
And you knew that there was a risk of high winds moving in with that weather.
We knew that it was raining and that it could be windy, yes, that's correct.
And knowing this, you made the decision to restart the tournament about an hour after that first pause.
That is correct. Mhm.
And shortly after that decision was made, the tree fell.
That is correct.
Thank you. Your Honor, I have nothing further at this time past the witness, if I may retrieve the documents.
You may. Waco National, cross-examination.
Yes, Your Honor.
All right, proceed with your cross-examination, counsel.
Good afternoon, Mr. Campbell.
Good afternoon.
Mr. Campbell, opposing counsel just asked you about cabling your trees.
Yes, sir.
Have you ever cabled your trees at Waco National?
No, sir, we have not.
Well, I want to talk about something they asked you about. They said that you were told about cabling by the Sterling Family Nursery, right?
That is correct, a long time ago.
I noticed they didn't ask you how long ago it was. When was that?
My recollection from the lead up in this case was 1997, 26 years ago, 22 years ago.
Is that about 25 years ago?
Yes, sir.
Mr. Campbell, when the Sterling Family Nursery, when you told them you weren't going to cable, did they say, we can't plant those trees unless you cable them?
Oh, no, they said that they understood fully.
You said they understood fully. Did they say that cabling the trees was required?
No, of course not.
Did they say cabling the trees made the trees less dangerous?
No,
Did they say, well, you better cable those trees or it'll be dangerous?
no, sir.
How many times did they tell you you needed to cable your trees?
They never told us to cable the trees.
Pass the
We
witness.
relied upon them.
Are you finished, Mr. Campbell?
Yes, sir.
Pass the witness, Your Honor.
All right. Sterling family, do you have cross-examination of this witness?
Yes, Your Honor.
Please proceed.
Good afternoon, Mr. Campbell.
Good afternoon.
I want to start off by talking to you a bit more about the relationship between yourself and the Waco National Golf Club.
Yes, sir.
Now, like you mentioned on direct examination, you've been with Waco National for over 60 years.
Yes, sir.
You started doing more hard labor, right?
I started by changing tires on golf carts.
And then you worked your way up.
Yes, sir.
And so for the past 30 years, you've been the head groundskeeper at Waco National.
Correct.
And as part of getting that position, you actually got an education.
That is correct, yes.
You have a degree in landscape management.
From Baylor, correct.
And as part of that education, you were taught about trees.
Yes, to some extent. I mean, obviously, landscape management involves the aesthetics of vegetation, types of trees used, et cetera.
Right, so it would be fair to say that you know the basics about trees.
Whatever the basics may be, I suppose, is subject to each person's perceptions.
Let's talk about what some of those basics might be.
I know how, I'm sorry.
No worries. Ms. Garabetian, would you please publish Exhibit 18 for the members of the jury, which has already been admitted, Your Honor? Would you please zoom into that second paragraph for me?
Your Honor, just as a point of order, this exhibit is not in evidence yet. It was shown during opening statement. It has not been admitted.
Are you going to move to admit this evidence, or what's your intended use here, counsel?
Yes, Your Honor. We do intend to admit this evidence.
Are you offering it through this witness?
Yes, Your Honor. We'll approach opposing counsel right now. May I approach the witness with Exhibit 18?
You may.
Mr. Campbell, you recognize what I just handed to you.
Yes, I do.
That's a letter that you received back in 1997 from the Sterling Family Nursery.
That is correct.
And that letter is in substantially the same condition as it was the last time you saw it, right?
Yes, sir.
Your Honor, the defense moves Exhibit 18 for identification into evidence.
Any objection?
No, Your Honor.
No objection from the plaintiff.
Exhibit 18's admitted. You may publish it now, counsel.
Yes, Your Honor, I apologize. Ms. Garabetian, if you would please zoom into that second paragraph. Mr. Campbell, it says here in this letter that you got from the nursery, I noted that none of the newly planted trees at the golf course are cabled to the ground, which we would think of as standard procedure with a newly planted tree until that tree has been in the ground for 8 to 10 years and had a chance to develop a stronger root system. I read that correctly, didn't I?
Yes, sir.
Mr. Campbell, we can agree that when it comes to trees, a tree with a stronger root system is safer than one with a weaker root system, right?
Objection, Your Honor. Calls for an improper opinion. May I explain?
Go ahead.
Your Honor, this witness is not an expert in trees. They're not an arborist. They don't have any sort of specialized training in trees. For opposing counsel to ask about the intricacies of root systems for trees, which trees are more stable or less stable based on their roots, the age of the roots, how long they've been in the ground, whether they were planted, placed, all of that is outside this witness's personal knowledge, and it calls for an improper opinion.
Your Honor, may I respond?
Please do.
At this point, I haven't asked this witness to give any type of opinion on this issue. Rather, we're asking this question specifically because either way that this witness answers is relevant for the jury to hear, given what would be reasonable for this witness. Your Honor, if the witness answers no, I don't know that stronger roots would be safer, the jury should be entitled to hear that.
May I respond, Your Honor?
No, I've heard enough, counsel. I'm going to sustain the objection. This calls for an opinion. This witness has a lot of experience as a groundkeeper, but there's no evidence that he's qualified as an expert, as an arborist, or as to the root system of trees. It's purely an opinion testimony. So I'm going to sustain the objection. Let's move on.
Yes, Your Honor. Mr. Campbell, you were told in this letter that cabling is standard procedure, right?
Yes, that's indicated in that sentence that you read.
And you're aware of what cabling is, aren't you?
Yes, sir.
Cabling is this process of attaching the base of a tree to the ground next to it.
Correct.
And we can agree that cabling is more safe than not cabling, right?
Objection, Your Honor. Calls for an improper opinion. Your Honor, if I could explain?
No, overruled. Answer the question, please.
In your own words, cabling is more safe than not cabling.
You want me in my words?
You said before, Mr. Campbell, that you
Actually,
recognize that.
I don't know about trees, and for a given tree, cabling may have no impact at all I just don't know about trees and what makes them safe. That's why we relied upon Lane and the Sterling Family Nursery.
So, Mr. Campbell, it's your testimony that you have no idea if cabling would have been more safe for your trees?
Well, like I say, a tree may not need cabling. I don't know when it needs cabling. If you have a big tree, it seems like cabling would be a waste of money even.
All right, let's move on, counsel.
Yes, Your Honor. Ms. Garabedian, you can take that down. After the tree nursery told you about this idea of cabling, you rejected cabling, didn't you?
We decided that we appreciated the mention of it, the mention that you just read, but we decided to not go in that direction.
Well, specifically, to you, cabling was a complete non-starter, wasn't it?
Well, we were concerned about the course is beautiful. We were concerned about the aesthetics of using cabling. We had input from the television network that broadcast the Legends tournament. The broadcasters were concerned about, and also the players.
Mr.
We
Campbell,
were concerned about the players too and the safety of the players, tripping and the like.
Counsel, if you think the witness is non-responsive, then you object, raise it with me, and I'll address the witness.
Yes, Your Honor. Mr.
And
Campbell.
Mr. Campbell, you need to limit your answers to the questions that are asked, all right?
Yes, Your Honor.
All right, let's proceed, counsel.
Yes, Your Honor. Mr. Campbell, as you just said, you were concerned with the aesthetics of the course, weren't you?
That was one concern, yes.
That's why cabling was a non-starter for you.
We decided not to cable, yes.
And like you said on direct examination, the tree nursery didn't bring up cabling again to you, right?
No, sir.
But you would agree that you wouldn't ever consider cabling, would you?
We had made a decision.
And that's a decision that you've maintained throughout the entire course of your relationship with that nursery.
The nursery never brought it up again, so we never did anything in response to what was never told us.
Let's move on, Mr. Campbell. Now, as part of this relationship with the nursery, you would actually go along on some inspections of the property, right?
That is correct.
These were inspections that happened every single year.
Yes, sir.
And one of those inspections occurred on March 31st, 2022.
Yes, sir.
During that inspection, like always, you walked around with Lane Harris.
That is correct.
And on that walk with Dr. Harris told you about how wet that golf course was, didn't he?
We had some casual conversation about it was a rainy spring.
Dr. Harris told you that because of how wet that soil was, those trees might not be as safe.
Oh, no. The extent of our conversation was just kind of some, I guess you might call it old person banter about the rain, the type of things that you do to make small talk. It's rained a lot. Yep, sure is wet. We need the rain.
So right, Mr. Campbell, it's your testimony that Dr. Harris never told you about this risk associated with a wet course.
No, sir, he did not.
Let's talk about what you knew. Mr. Campbell, in your own words, it had rained a lot in the months leading up to the Legends tournament, right?
As I indicated, it was a rainy spring, yes.
I want to talk about just how much rain there was. Your Honor, I'm approaching opposing counsel with what's been previously marked as Exhibit 39 for identification. May I approach the witness with the same?
You may. And counsel, there's no need to tell the jury what you want to talk about. That's an impermissible sidebar comment. If you want to ask the witness a question, that's perfectly fine, but making a statement that's not a question in the presence of the jury about what you intend to talk about is not permissible. Understood?
Understood, Your Honor.
All right, ask your question.
May I approach the witness?
Approach the witness and ask a question.
Mr. Campbell, you recognize what I just handed to you?
It's a it's a log of rainfall.
Do you recognize it, Mr. Campbell?
Yes.
That's the question, not what is it, but do you recognize it?
Yes, sir.
Okay.
And it's in substantially the same condition as the last time that you saw it, right?
That is correct.
This is a rain log that you remember looking at in the months leading up to your golf tournament.
Correct.
Your Honor, the defense moves Exhibit 39 for identification into evidence.
Is there objection?
No objection, Your Honor.
Your Honor, we would object to hearsay to this document, to the statements contained therein, specifically the numbers related to the rain log.
What's your response, counsel?
Your Honor, we're using this rain log for its effect on the reader of that rain log. Your Honor, we have a good faith that in preparing for the Legends Golf Tournament, Mr. Campbell looked at this rain log and relied on this rain log as far as making decisions about whether or not to postpone the tournament, whether or not to continue on with the tournament. Therefore, the effect on the reader of this rain log is what's relevant to determining what would have been reasonable.
Mr. Campbell did not generate this information. This is hearsay information, correct?
Right, Your Honor, but we're not using
What's the exception?
We're not using it for the truth of the matter asserted, Your Honor.
Any further response?
Your Honor, opposing counsel in their preceding questions asked repeatedly about how rainy it was. They're clearly using it for the truth, to show how rainy it was, not the effect.
I'll permit it for the use regarding the state of mind of this witness, but not as to the factual truth or accuracy of what's represented in it. All right?
Understood, Your Honor.
All right, it's admitted with that caveat.
Yes, Your Honor.
And objections overruled. For
Ms.
the record.
Garabedian, would you please publish Exhibit 39? Thank you. Mr. Campbell, on this rain log that you read yourself, you can see that in March 2022, as far as you knew, there were 15 inches of rain, right?
That's what the log indicates.
And March 2022, the March of every year, is just a month before your tournament, isn't it?
That's correct.
Mr. Campbell, looking back throughout the years in March, you saw that 15 inches that year was higher than anything you've seen before in March.
Objection, Your Honor. At this point, I would re-raise my objection. This is going into the truth of the log, not the mindset of this witness. They didn't ask about what he did with this information. They're delving into the details. They're saying this is so much more than before, this was 15, that was 4. Your Honor, this is going beyond the limit.
Your Honor, may I respond?
No, it's overruled. Part of his state of mind is the comparison from this year to prior years. Again, this is not represented to the jury as factually accurate. It's represented to the jury and is evidence with regard to what was in the mind of Mr. Campbell when the decision was made or not made to delay the tournament. And you're going to use it only for that purpose.
Yes, Your Honor.
All right, let's proceed.
Yes, Your Honor. Mr. Campbell, you saw that in March 2022, as far as you were aware, there was more rain in that month, that year, than in any of the previous Marches.
That's correct.
And despite that, Mr. Campbell, you never thought to delay your tournament, did you?
No, but we do look at the conditions on the ground of the course.
Let's talk about the conditions on the ground of the course. Your Honor, we're now publishing Exhibit 40, which has already been admitted.
All right.
Mr. Campbell, this is a photograph of your golf course from mid-March 2022, isn't it?
I'm uncertain of the date, but it's in the springtime, yes.
You are aware that this was a photograph that was taken at least in the month leading up to your tournament, correct?
Correct.
And you can see in this picture that there's water on top of that grass.
There's a big puddle.
And in your own words, you were concerned on a daily basis about the conditions of your course.
We take care of it, yes, day to day.
I'm not asking about who else took care of it. I'm asking about what you felt, Mr. Campbell. You were concerned on a daily basis because of how wet the course was.
I'm concerned about the condition of the course in terms of its playability, its beauty, the vibrancy of the vegetation. I'm a groundskeeper.
But after you saw this condition of the course, you didn't stop watering it, did you?
No, puddles come and puddles go.
You didn't wait for the course to dry up.
I don't know what we did with that puddle. I don't keep track
You didn't
of
consider.
puddles.
Excuse me, Mr. Campbell, I apologize. Did you get a chance to finish?
Oh, you're asking me, if I may, questions about, I suppose, this puddle. I don't know if that occurred immediately after a rain or if it had been sitting there or the like. I don't know.
Well, let's talk about what you did after that. You would recognize a log of how you watered the course after the inspection if I were to show it to you, right?
Of course.
Your Honor, I'm approaching opposing counsel with what's been previously marked as Exhibit 41 for identification. May I approach the witness with the same?
You may.
Mr. Campbell, you recognize what I just handed to you.
This is our water log.
That is a log of how the course was watered between April 1st and April 8th, correct?
That's correct.
And that document was prepared by the Waco National Golf Club,
Correct.
and it's in substantially the same condition as it was the last time you saw it.
Correct.
Your Honor, the defense moves Exhibit 41 for identification into evidence.
Any objection?
No objection from the plaintiff.
None, Your Honor.
It's admitted.
Mr. Campbell, you can see looking at this log that between April 1st and April 8th, the course was watered every single day.
Correct.
It was watered twice a day throughout all of those days
Correct.
for a total of 45 minutes each day.
Correct.
You can see that it was watered all the way up until April 8th, 2022.
That's correct.
That's the day that a tree fell on the golf course, isn't it?
Yes.
The golf course made the decision to water that course every single day until the tournament itself,
That's what we do to take care of the course.
to make sure that it's green, right?
Yes.
To make sure that it's beautiful.
And to help the vegetation and multiple reasons.
Lastly, I want to show you a photograph from your golf course. Your Honor, for the record, we're publishing now Exhibit 8, which has already been admitted.
Proceed.
All of those trees on the golf course, Mr. Campbell, the golf course decided where they should go.
Yes, we make decisions about where we need trees or where we don't need them.
Mr. Campbell, you answered the question fully when you said yes. Limit your answers to the questions asked, please.
Yes, Your Honor.
The golf course decided when to plant those trees.
Correct.
The golf course decided how to plant those trees.
We don't know how to plant a tree.
You decided cabling wasn't necessary. Your words.
There was the 1997 discussion of it.
Yes or no, Mr. Campbell, you decided cabling wasn't necessary.
In 1997, yes.
And thereafter.
It never came up after that.
Nothing further, Your Honor.
You pass the witness.
Yes, Your Honor. May I approach to retrieve an exhibit?
You may. Is there further direct examination?
Your Honor, I have no redirect.
All right. You may step down, Mr. Campbell. Ladies and gentlemen of the jury, we're going to take a short recess at this point. Remember all the instructions I've given you about your conduct, including not to discuss the evidence among yourselves. We'll be back here shortly to continue. The court stands in recess. Be seated, please. Counsel, so you'll be aware of your remaining time in this trial. Plaintiff has 24 minutes and 11 seconds remaining. Waco National has 43 minutes and 10 seconds remaining. And Sterling Family Nursery has 27 minutes and 31 seconds remaining. All right, we'll continue with the plaintiff's case in chief. Counsel, call your next witness.
Yes, Your Honor, at this time, the plaintiff calls Lane Harris. And again, for the court's note, Lane Harris is the party
You're calling
representative.
him adversely.
Yes, Your Honor.
All right, you're entitled to lead him on direct, and he's a representative for Sterling Family, so on cross-examination, Sterling Family will treat him as if he was a direct witness and will not lead. All right, this witness has been sworn. Please have a seat, sir. Counsel, you may proceed with direct examination.
Yes, Your Honor. Good afternoon. Your name is Lane Harris,
It is.
and you work for the Sterling Family Nursery.
I do.
You're an arborist with the Sterling Family Nursery.
I am.
An arborist, Dr. Harris, is just someone who specializes in trees, right?
Well, a little bit beyond that. I specialize in plants that have bark, I think is a more accurate way of phrasing it.
And you have a PhD in arboriculture
And forestry, yes.
and forestry. And you've worked in your role as an arborist with the Sterling Family Nursery, you've worked with Waco National Golf Club for several decades now.
That is correct.
And the relationship that Sterling Family Nursery has with Waco National Golf Club is that you supply the trees for the golf club.
We do.
The golf club orders pine trees from you, right?
Yes.
And you,
And other types of trees.
and other types of trees, but you, as the nursery, install those trees into the golf club.
We do.
Let's walk through a little bit the installation process of one of these trees. Now, these are mature trees that you're installing.
Well, I mean, we don't always install mature trees, but I think the ones that you're talking about in this case were mature trees, yes. We sell saplings as well as mature trees. In fact, most of our business is selling saplings, smaller trees.
But you're,
Just a minute. Dr. Harris, pull the microphone a little closer or speak up so that everyone can hear you. It's a
That
large
better?
courtroom. That's better. Thank you.
but
Please
your
continue.
business, yes, Your Honor. But your business with Waco Golf Club, that concerned mature trees.
I mean, about 100 of them perhaps, yes, but I mean, not every tree we sold was a mature tree.
Right, over the course of the past 25 years, you've planted about 100 trees on the Waco National Golf Club.
That's about right, yes.
When you go and plant these trees into the golf club and into a golf course, you're using something called a root ball, right?
Well, that's what's part of the tree, yeah. That's when we remove the tree from our premises, we remove it with a root ball attached, yes.
And a root ball is just the primary roots of the tree, but just scaled down some so it will fit into the hole.
Yes, and yes, it's a cluster of the roots from that particular tree.
And once you place one of these trees into the ground, that tree isn't stable at first.
No.
In fact, it takes about 8 to 10 years for one of these trees to become stable on its own.
Yes, I mean, when you put it in there, it doesn't just fall over. I mean, it's stable to the extent that it will stand up.
Right, gravity's holding it down. at that point.
Yeah. And so, but for it to become what we would consider as a professional, fully sort of integrated into the ground so that the danger risk is minimized, it takes 8 to 10 years, yes.
And that phrase that you just used, the danger risk being minimized, over 8 to 10 years, that's when that danger risk is highest of the tree falling.
It is.
One of the methods that are available, in fact, to prevent a tree from falling is called cabling.
That's
Right.
correct.
And what cabling does is that it attaches the tree to the ground using ropes of some sort.
Well, it doesn't attach the tree to the ground. What it does is it attaches cables that are connected to the tree to the ground. There's stakes, and the stakes are placed in the ground. The tree, it doesn't do, I mean, the tree is what it is before and after, but we attach these cables on multiple sides, and those cables then are staked into the ground.
Right, and that stabilizes the tree.
Yes.
Keeps the tree from falling over in wet conditions.
It would definitely help in that situation, yes.
Now,
And
Dr.
windy
Harris-
situations as well.
Dr. Harris, where the conditions are right and a tree has not been cabled into the ground, it's at a higher risk of falling over.
That's correct.
Let's talk about what those conditions are. Wet soil makes a tree more likely to fall over.
Yes. Well, I mean, a new tree, a tree that hasn't established a root system, yes.
Right, one of these unstabilized trees is more likely to fall over in wet soil.
Yes.
And the wind can exacerbate this as well.
Yes.
Now, the tree that we were talking about here, the tree that we're dealing with in this case, it was not cabled to the ground.
No, the golf course would not cable their trees
Right, the golf course over 25 years ago refused to cable the trees.
and had never asked us to cable one since.
Now, you say that they never asked you to cable one since, but in the 25 years since they refused to cable those trees, you never once again even suggested cabling as an option.
Well, that's not our call. It's the call of the purchaser. And so we show up at the tree and plant it, and they tell us what they want us to do with it.
You never raised cabling as an option in those 25 years, though.
Well, why would I raise it over and over again when I'm told almost hostilely the first time that cabling is not something this course would ever consider because of the aesthetics and the other reasons that have been reported?
Dr. Harris, yes or no? You did not suggest cabling as an option in the 25 years of your relationship after that first time.
It wasn't necessary to, no.
You also didn't suggest any other type of stabilization options.
There weren't other really appropriate stabilization methods for this particular tree.
But you never suggested any other stabilization options in the 25 years of your relationship.
There were no, well, I said there weren't circumstances that would have justified that, so no.
Well, let's talk about what happened in 2022. Now, every year you went out and inspected the Waco National Golf Course.
Every year I walked the course with Mr. Campbell, yes,
Now, you were here in court earlier when Mr. Campbell testified, right?
I was.
And did you hear Mr. Campbell, and you heard Mr. Campbell say that he never had a conversation with you about soggy conditions on the course creating a risk of a tree falling?
I heard him say that.
And Mr. Campbell, you would disagree with that, right?
Of course, because we had that conversation. Can't understand why he's lying about it now, but we had that conversation.
That's right. You went out to the course and you observed soggy conditions.
I told him that there were soggy conditions, yes.
You also told Mr. Campbell that there was a risk of a tree falling.
I told him there was a risk of the trees that we had planted in the last decade because of the soil conditions. I did, yes.
And the tree in this case was planted in the last decade.
Yes.
Thank you. Nothing further. Pass the witness.
All right. Cross-examination by, this is the representative for Sterling Family. You may go first on cross-examination.
Your Honor, we'd actually elect to examine Dr. Harris in our case in chief, and we'll pass up on that opportunity at this time.
That's fine. You have the right to call him in your case. Then I'll ask for cross-examination from Waco National.
Yes, Your Honor.
All right, proceed with cross-examination of this witness.
One second, Your Honor. I just want to make sure the tech's good to go before I start.
All right.
My apologies, Your Honor. Good afternoon, Dr. Harris.
Good afternoon.
You have a PhD in arboriculture, right?
I do.
That's, like you said, the study of plants with bark, trees.
Yes,
You've been working with trees for over 30 years.
that's correct.
You know how to plant trees.
I do.
You know how to grow trees.
I do.
You know how to inspect trees.
I do.
You can consider yourself an expert.
I am.
In 1997, the Waco National Golf Course hired your company, the experts, to install their trees.
To install some trees
And
in
to
1997.
To install some new trees for them, right?
Yes.
Then they asked you to inspect the trees.
I'm not quite sure I followed that. We were not contractually committed to, in any sort of way with inspection. I mean, they didn't hire us to inspect the trees. We voluntarily came down and inspected the trees. And of course, that's because the contract you all signed said that once the trees were in the ground, you were entirely responsible for their care and maintenance and inspection.
Dr. Harris, I just want to make sure I'm clear. You said a lot of things there, but my question was very simple. You agreed to inspect the trees, right?
No, not in a contractual way. We voluntarily came down and would inspect the trees. So if you'll clarify your question, then I can clarify my answer. Are you asking?
All right, just a minute. We're not going to have a conversation here. He asked a question, if you inspected the trees, whether it was contractual or voluntary, you need to answer the question. And, you know, we're not going to have this back and forth discussion. This is an examination in the United States District Court. It's not a conversation on the street corner. I expect clear questions, and I expect direct answers limited to the context of the question. And let's go forward on that basis. State your next question, counsel.
You inspected the trees, right?
We voluntarily inspected the trees.
You started inspecting the trees back in 1997.
We did some inspection voluntarily back in 1997, yes.
I want to look at your most recent inspection. Your Honor, I'm approaching opposing counsel with what's marked for identification as Exhibit 30.
That's fine, but counsel, you don't need to tell this jury what you want to look at. You need to ask this witness questions.
My
all right?
apologies, Your Honor. And may I approach the witness?
You may approach the witness.
Dr. Harris, I just handed you Exhibit 30. That's a copy of the inspection report you filled out, right?
It's an email, yes. This is an email,
This is an email you sent to Rory Campbell.
yes. There was a separate inspection report. This is not the inspection report. This is the email I sent.
Well, I just want to make sure I'm clear. This is the email you sent, right?
It is, yes.
You sent it to Waco National Golf Club.
I sent it to Mr. Campbell, yeah.
It's a fair and accurate copy.
It is.
Waco National offers Exhibit 30, Your Honor.
Is there objection? No objection.
No objection.
Exhibit 30 is admitted.
Ms. Schaefer, can we put it on the screen? Mr. Harris, this is your official inspection report, isn't it?
This is what I sent to Mr. Campbell, yes.
That's a yes. This is your official inspection report.
It's an email of the summary of my inspection report, yes.
Mr. Harris, you said this is the official inspection report, right?
Yes, it's an email.
On direct examination, you said that wind can exacerbate young trees, right?
Well, depending on how they're planted.
But that's what you said just a moment ago in a previous questioning, right?
If they're not stabilized, yes.
In your inspection report, you didn't mention wind once.
Not in the email, no.
In the previous question, you said wet soil makes a tree unstable. Right?
Yes. Is that a question? Yes.
In your official inspection report, you didn't use the word soil once.
I did not mention in the email, no.
You talked about a conversation you claim you had with Rory Campbell. You didn't reference any part of that conversation in your official inspection report.
That wasn't the practice.
I'm not asking if it was the practice, I'm asking if it's what you did, and you didn't.
I did not reference it because it was not the practice.
Again, I'm not asking if you did.
Counsel, I've already instructed your co-counsel. If you believe the witness is non-responsive, don't argue with the witness, raise it with the court, and the court will deal with him.
Certainly
All
not.
right? And while I've got you two stopped, we're going to stop this quibbling about it's an inspection report or an email. It says on its face it's an inspection report. It's delivered by way of email. I don't care if it's written in hieroglyphics on parchment paper. It is an inspection report, and it says so. And we're not going to confuse the record by going back and forth about this inspection report. No, it's an email. Exhibit 30 is Exhibit 30, and we're going to call it Exhibit 30, and we're not going to quibble about what it is or how it was sent or the method of delivery. Understood? Do you understand that, counsel? Do you
Absolutely.
understand that, Dr. Harris?
Yes.
All right, let's proceed.
In Exhibit 30, you said there were no issues with the trees.
I said I could not find any issues with the trees. That's correct.
In Exhibit 30, you said there were no major safety concerns.
I said there were no issues that would raise any major safety concerns, yes.
Pass the witness.
All right. Is there anything by way of redirect examination?
No redirect, Your Honor.
And Sterling National's elected to call him in their case in chief. So you may step down, Dr. Harris.
Somebody want the exhibit?
Leave it there at the witness stand.
Your Honor, if I could approach and get that, make sure.
You may take it back.
Thank you.
All right, counsel, for the plaintiff, call your next witness.
Your Honor, at this time, the plaintiff rests.
All right. Is Waco National prepared to go forward with its case in chief?
We are, Your Honor. Before we do, we would move for a judgment as a matter of law under Federal Rule of Civil Procedure 50, even viewing the evidence in the light most favorable to the non-moving party, the plaintiff. No reasonable jury could find they've met their prima facie burden.
Well, your motion under Rule 50A is denied at this point after the close of all the evidence. I'll consider any motions from either party under Rule 50A, and you may re-urge it at that time.
Certainly.
Call your first witness.
Your Honor,
Excuse me, that we would also like to raise at this time a motion outside the presence of the jury, same motion of Rule 50A from
And
Sterling family.
I've already said, counsel, I'll consider motions under Rule 50A after the close of all the evidence. If you read the rule, it clearly says at any time before the case is submitted to the jury, a party may move for judgment as a matter of law under Rule 50A. There's nothing in the rule that says when it has to be urged. I will hear them after all the evidence from all three of the parties.
Understood, Your Honor.
Okay? Call your witness.
Waco National Golf Club would recall Rory Campbell to the stand.
All right, Mr. Campbell, please return to the witness stand. You remain under oath. All right, counsel, proceed with direct examination.
Mr. Campbell, could you just restate your name for the record?
Rory Campbell.
Mr. Campbell, I know you were up here earlier, but I want to talk about a few more things that you didn't quite get to. Now,
Yes,
Mr.
sir.
Campbell, you were asked about the date of April 8th, 2022. What was happening at the Waco National Golf Course that day?
The Legends tournament.
You were asked a little bit about the weather. Did the weather get worse throughout that day?
Your Honor, I would object to ask and answer. This testimony has already been elicited.
Overruled. This is his case in chief. He's entitled to put on his evidence. If it gets highly redundant, you can re-urge it, but I'm going to give you some latitude at this point.
Yes, Your Honor.
Let's proceed.
There were indications that the weather would worsen as the day went on, windier.
Were you finished up? My apologies. Earlier, you said that you eventually suspended play. Why did you suspend play?
We suspended play because there were players out on the course, and the conditions with the wind became such that we being the tournament committee, the PGA rep, and myself, believed it would be unfair to the players to have play continue at that point.
Mr. Campbell, at any point during that day, did you tell the spectators to leave the course and seek shelter?
After the second suspension of play at 4:22, an air horn was sounded, and that suspends play for the players. Then there was also a siren that was sounded, and that is understood by the spectators to tell them to please vacate the course.
I want to talk about how the trees looked at the Waco National Golf Course. Ms. Schaefer, can we get Exhibit 8 back on the screen? Mr. Campbell, what are we looking at here?
It's the tee box for the 17th hole.
Are you aware that on April 8th, one of those trees came down and injured the plaintiff?
Yes.
Did Waco National plant that tree?
No, sir.
Who did?
The Sterling Family Nursery.
You said it was the Sterling Family Nursery. When did you first hire the Sterling Family Nursery?
Oh, long time ago. I can't remember the year. Long time ago, decades.
Does 1997 sound about right?
Yes, yes, sir.
What would you do to make sure those trees weren't a fall risk?
I did not understand. What would I do? Please repeat.
Absolutely, Mr. Campbell. After you had the trees planted by Sterling Family Nursery, what would Waco National do to make sure they were safe?
We would rely on Sterling Family Nursery.
How would you rely on them?
Well, there were the annual inspections that the nursery made, and we're not experts, my heavens, in trees, and we would rely upon the nursery to be monitoring the trees at all times.
Mr. Campbell, did you believe your tree was safe on April 8th, 2022?
Yes, sir,
Why?
because we had never been told otherwise, and we relied upon Lane and the Sterling Family Nursery.
I want to talk about the parts of tree maintenance that you were responsible for. What parts were those?
Oh, we can do the simple stuff. We water the trees when necessary. If there are some branches, for instance, that need pruning and they're real low to the ground, we can take care of that. Beyond that, really, we leave it to the Sterling Family Nursery.
Mr. Campbell, I want to be clear. You mentioned you dealt with the watering. Were you aware that if soil was too wet, a tree could potentially fall over?
It's not something that is on my mind or the mind of my team.
Did you know that was a possibility if the soil was wet?
No, actually, trees are solid, and we have no reason to know that the water could bring out a big tree, bring it out of the ground. No, sir.
Well, Mr. Campbell, you said that the Sterling Family Nursery had yearly inspections. When was the last time they were out on the course before April 8th?
It was that week prior, that I was talking about a while ago, March 31.
When they were on the course on March 31st, did they tell you, don't let spectators sit near that tree because the ground's too wet?
No, sir.
When they were on the course, did they tell you, don't let spectators sit near the trees, that one might come down?
No, sir.
What did they tell you about the safety of your course?
They didn't tell us anything.
Well, did they tell you whether or not your course was safe?
By reason of not indicating otherwise, yes, that's the purpose of the inspection.
And Mr. Campbell, did Dr. Lane Harris send you an inspection report after the visit?
Yes, sir.
And in that inspection report, did Dr. Harris say whether there were safety concerns?
He said there were none.
Thank you, Your Honor. Pass the witness.
All right. Plaintiff, do you have cross-examination of this witness?
Yes, Your Honor.
Please proceed.
Mr. Campbell, you suspended play at the golf course because the ground was getting too wet on April 8th.
We suspended play because of the conditions. The wind, in particular, was making play unfair for the golfers who were still out on the holes and the fairways.
Right, at the end of the day, you suspended because of wind, but towards the beginning of the day, you also suspended because of the rain.
Yes, it was raining. That is correct.
Your Honor, I have nothing further.
You pass the witness.
Yes, Your Honor.
Sterling Nurseries, do you have cross-examination of this witness?
Yes, Your Honor.
Please proceed.
Mr. Campbell, just now on direct examination, you were asked about what Sterling Family Nursery did or didn't tell you. Did you ever tell Sterling Family Nursery where you would be using those trees on your property?
I don't understand your question.
Did you ever tell the nursery if the trees they were planting would be right next to a tee box?
We told them where we wanted trees to be planted, yes.
You never told them where those trees would be in relation to guests, though, did you?
I'm not understanding. We told them to plant trees here, and if I may add anything else, if the tee box is X number of feet away, it's pretty clear that the tree is near a tee box.
Let me make it a bit simpler, Mr. Campbell. You never told Sterling Family Nursery that guests at your course would be sitting directly underneath trees, did you?
No, but there's some things that are obvious.
You never told Sterling Family Nursery that guests at your golf course would be surrounded by the trees that they planted.
Same answer.
That's a no to my question.
It's that some things are obvious, and if there are trees on a course, the spectators are going to be underneath the trees.
Well, Mr. Campbell, you say that must be obvious. Did you hire Sterling Family Nursery to help design your golf courses?
Not to design the course, no.
You only hired that nursery to plant trees, isn't that right?
We hired them to install trees and to maintain safe conditions of the trees as experts.
Just the trees, not your courses.
No, we designed the course.
Nothing further, Your Honor.
You pass the witness.
Yes, Your Honor.
Is there any redirect?
No, Your Honor. May Mr. Campbell leave the stand but remain in the courtroom, obviously.
Mr. Campbell may step down. All right. Who's the next witness for Waco National?
Waco National calls Dr. Avery Olson.
All right, Dr. Olson, please come forward. Dr. Olson's previously been sworn. Please have a seat on the witness stand, Dr. Olson. Counsel, proceed with direct examination.
Yes, Your Honor. Good afternoon. Can you please introduce yourself to the jury?
Yes, I'm Avery Olson.
What do you do for a living?
I am a professor of plant biology at the University of Georgia.
And how long have you been a professor?
About 15 years.
Now, Dr. Olson, were you asked to investigate a cause of a tree fall that happened at the Waco National Golf Course on April 8th, 2022?
Yes.
Before we get into your opinion, I want the jury to get a sense of your credentials. What degrees do you hold?
I have a bachelor's degree, I have a master's degree, and I also have a PhD in plant biology.
Have you ever studied the safety of trees?
Yes.
Have you ever studied the risks of trees falling?
I've looked at the things that can cause trees to fall, and for safety reasons, yes.
Have you ever studied how different conditions can affect the risks of trees falling?
Yes.
Where did you study that?
Well, again, that was part of the studies that I did at the University of Georgia. It's something that I also do in the lab that I am the director of. And so both in my studies as well as what I've done since graduation, since earning my PhD.
Dr. Olson, pull the microphone a little closer to you, please. Thank you. Please continue, counsel.
Yes, Your Honor. Dr. Olson, are you being paid by my office for your work today?
Yes, sir.
How much?
Well, I've been paid in the past $750 an hour for work that I did leading up to the trial. And then for my testimony and being here today, I'm being paid $1,000 an hour.
Dr. Olson, have you ever served as an expert in a tree falling case before?
I've served in some cases, yes.
Waco National offers Dr. Olson as an expert in the field of plant biology with a specialty in tree fall cases.
Is there objection?
No objection, Your Honor.
No objection, Your Honor.
Court will recognize this witness as an expert in those designated fields. Continue with your direct examination, counsel.
Dr. Olson, do you hold all of your opinions to a reasonable degree of professional certainty?
I do.
And what materials did you review in coming to your opinion?
I reviewed the various depositions that have been taken in the case, the exhibits that I was provided, to see what had happened and what evidence there was out there.
And were those materials sufficient to form the basis of that opinion?
Yes, they were.
What principles and methods did you use in forming your opinion?
Well, I took into consideration the advice that Waco National had been given by its nursery, Sterling Family Nursery, and compared to what you would have expected an expert to give as advice to their client.
And is that method reliable?
Absolutely,
Did you reliably apply that method to today's case?
absolutely.
Dr. Olson, who inspected the trees at the Waco National Golf Course?
Well, that would be Sterling Family Nursery.
In the 3 years before the accident, how many times did they inspect it?
At least 3 times. And it seems like from all the evidence that they were out there inspecting every year on an annual basis.
Dr. Olson, how many issues for safety did the tree nursery identify?
They didn't identify any.
We know a tree fell and injured the plaintiff. Dr. Olson, in your opinion, what could have been done to stop this?
Well, I think the best thing that could have been done is for Sterling Family Nursery to advise its customer what to do about those trees to make sure that there was no risk of them falling.
I want to break that down. You said the Sterling Family Nursery performed the inspections.
Yes.
Dr. Olson, what kind of nursery are they?
I believe that they raise trees, they're a tree nursery.
And do you know when they began working with Waco National?
The earliest I saw was probably right around 1997.
Dr. Olson, you said they started working in 97. Did you find evidence of any other safety inspections performed at Waco National that weren't done by the Sterling Family Nursery?
No.
Okay, Dr. Olson. Your Honor, I'm approaching opposing counsel with what's marked for identification as Exhibits 28 and 29 and what's in Evidence Exhibit 30. May I approach the witness with the same?
You may.
Dr. Olson, I just handed you what's marked for identification as Exhibits 28, 29, and 30. Can you tell us what those are?
They are 3 memos with different dates from from Lane Harris to Roy Campbell about inspection reports. In fact, they start out, this is my official inspection report. Each one starts that way.
Are they fair and accurate copies?
Yes.
Waco National offers 28 and 29.
Is there objection?
No objection.
No objection.
They'll be admitted.
Ms. Schaefer, can we get those on screen? Let's start with the 2020 report. According to the Sterling Family Nursery, how many issues did they identify with the trees in 2020?
It says I did not find any issues with any of the trees on the property.
According to Sterling Family Nursery, how many safety concerns were there in 2020?
There are none noted in this report.
Let's move to 2021. According to Sterling Family Nursery, how many issues were there with the trees in 2021?
None.
According to Sterling Family Nursery, how many safety concerns were there with the trees in 2021?
None.
Let's move to 2022. According to the Sterling Family Nursery, how many issues were there with the trees in 2022?
None.
According to the Sterling Family Nursery, how many safety concerns were there with the trees in 2022?
There are none noted.
Dr. Olson, how many days after that the inspection report, was sent, did the accident happen?
I believe it was approximately 4 days after the inspection, thereabouts.
Thank you, Dr. Olson. Pass the witness, Your Honor. May I approach and get those exhibits?
You may. Cross-examination by the plaintiff.
Yes, Your Honor.
May I proceed?
Please do.
Dr. Olson, I want to pick up where you just left off. Now, Mr. Doig just asked you about the email reports that you received or that you reviewed, right?
Correct.
Now, Dr. Olson, you didn't hear all of the conversations that took place between the Sterling Family Nursery and the Waco Country Club, or the Waco Golf Club.
No, I wasn't there.
And you don't know if the nursery ever did provide a warning to the golf club about the conditions of the trees.
There was no warning that I observed.
But you don't know if there ever was a warning given.
No, I don't.
Well, you mentioned conditions, so let's talk a little bit more about the conditions that were on the course. The conditions that were on the course in 2022 before this tournament created a risk of a tree falling.
Sorry, can you repeat your question?
Yes, the conditions on this course in 2022 during this tournament created a risk of a tree falling.
Objection, Your Honor. It calls for an improper opinion. May I explain?
Is this within the scope of your expert's report?
Your Honor, this witness is an expert in tree falling generally, but to go into this specific instance on a golf course is improper. We don't have any expertise for them related to golf courses and things like that.
Well, notwithstanding your explanation, let me ask my question again. Does this opinion find itself within the confines of this expert's report that she tendered under the rules prior to this trial?
Your Honor, we don't have an official report. We do have the deposition testimony. So it's not within a report. That is in the deposition, but not in an official report tendered.
Does the plaintiff have a response to the objection?
Your Honor, the defense tendered Dr. Olson as an expert in trees, and as Mr. Doig just explained, tendered her as an expert in trees falling. The conditions in which trees fall, well, that's what I'm asking about. I'm not asking about specifics to a golf course. I'm just asking about the conditions being right for a tree to fall, which is in her expertise.
Well, clarify something for me, counsel. Did this witness prepare and tender a written report setting forth her opinions prior to her testimony today?
No, Your Honor.
No, Your Honor.
All right. Then in light of that, I'll overrule the objection and I'll allow the question to go forward.
Yes, Your Honor. So just to state that one more time, Dr. Olson, the conditions on this course created a risk of a tree fall.
Well, the conditions were very unusual, and as a result of those things happening, the answer is yes.
The conditions were partly because of the wet soil on the golf course.
That was part of it, yes.
And another condition was the high wind, right?
Correct.
And on April 8th of 2022, both of those conditions were present.
Yes.
And on April 8th of 2022, the tree fell.
Yes.
Thank you, Dr. Olson. Nothing further, Your Honor. Pass the
All right.
witness.
Is there cross-examination by Sterling Family Nurseries?
Yes, Your Honor.
Please proceed.
Good afternoon, Dr. Olson.
Good afternoon.
I want to talk to you about your work with Waco National Golf Club in this case. Like you mentioned on direct examination, that firm hired you.
Yes, Waco family?
Yes.
Yes.
And you've performed around 9.5 hours of work on this case, right?
That's approximately right, yes.
Like you mentioned, so far you've charged over $7,000.
Well, I didn't mention that, but that is correct.
Well, let's actually take a look at an invoice for your work on this case thus
Sure.
far. Your Honor, I'm approaching opposing counsel with what's been previously marked as Exhibit 46 for identification. May I approach the witness with the
You
same?
may.
Dr. Olson, you recognize what I just handed to you.
Yes.
This is an invoice for the work that you've done so far for Waco National.
That's correct.
And it's a document that's regularly produced in your course of business.
Yes.
And it's in substantially the same condition as it was the last time you saw it, right?
It appears to be, yes.
Your Honor, the defense moves Exhibit 46 for identification into evidence.
Any objections?
None, Your Honor.
It'll be admitted.
Your Honor, we're now publishing Exhibit 46. Dr. Olson, you can see here that of that 9.5 hours, you spent 2 hours on the phone with these attorneys right here.
That's correct.
You spent another hour with these attorneys to discuss your opinions regarding this case.
Yes.
You spent another half hour with those same attorneys to prepare for your deposition in this case.
Yes.
So of that 9.5 hours, Doctor, you spent 3.5 hours with the attorneys for Waco.
Yes.
Over a third of your time spent in this case was just spent with the attorneys.
Yes.
Thank you, Ms. Garabetian. Now I want to move on to some of your opinions in this case. You said that what happened here at this golf course wasn't very likely, correct?
That's correct. It was an unusual set of circumstances that converged on that date.
You've called this set of circumstances a perfect storm, right?
Yes,
And that included factors like wet soil,
extremely wet soil, yes.
wind speeds of like 25 to 30 miles per hour,
That was certainly one of the conditions, yes.
and then trees that aren't very stable.
Well, it turned out that the tree that fell was not very stable, yes.
But Dr. Olson, you call this the perfect storm, but a regular storm has wind.
Well, to different degrees of how fast or what the sustained winds are and what the gusts are, but yes.
A regular storm has got rain a lot of the time.
Yes, again, it can vary as to how much rain there is, but yes.
And yet, in this case, you say that the odds of this happening were astronomically small. Your words.
Yes.
But you never calculated the odds of that happening, actually.
Well, no, I didn't calculate the odds, but it's really, you also forgot the other thing that made it a little bit unusual, that the golf tournament would have happened after a particularly rainy month and some days into April, that there would be spectators that were out there. So it's a combination of all those things converging at one time in one place that resulted in the unfortunate injury to Mr. Draper.
But it's your opinion, Dr. Olson, that Waco National Golf Club, they couldn't have seen this coming.
Well, they had an expert that was supposed to tell them that it was coming, and when that expert failed to do that, that certainly caused problems.
You're aware that Waco National is the one who invited all of those spectators onto their property.
Yes.
You're aware that Waco National are the ones who could have stopped that tournament whenever they wanted to.
Well, yes, and if they'd had a reason to believe it was unsafe, I presume that they would have.
You're aware that Waco National did stop the tournament that day, correct?
Yes.
But it was only after that tree fell on Mr. Draper.
Well, I mean, there were some pauses before that, as I recall, some stoppages.
But they only stopped the tournament completely after that tree fell, correct?
Yes.
Pass the witness.
All right. Is there further direct examination?
Yes, Your Honor.
All right. Proceed with redirect.
Dr. Olson, you were just asked about the conditions of the course on the day of the accident.
Yes.
Now, are you aware that the conditions of the course, they were soggy?
I've seen some things in the evidence that suggested that the soil was soggy, yes.
Dr. Olson, in all the evidence you reviewed, did you find any evidence that Sterling Family Nursery ever told Waco National, watch out with those trees when it's soggy?
No, I did not see that.
Pass the witness.
Any further cross from the plaintiff?
Nothing further, Your Honor.
Any further cross from Sterling Family Nursery?
Nothing further, Your Honor.
You may step down, Dr. Olson. Just,
May I retrieve the document from the...
yes, take the exhibit from the witness, please.
Yes, Your Honor.
All right, Waco National, call your next witness.
Waco National rests our case.
All right. We'll proceed with the case in chief from Sterling Family Nurseries. Call your first witness.
Yes, Your Honor. We call Dr. Lane Harris to the stand.
All right, Dr. Harris, if you'll return to the stand, you remain under oath, sir.
Your Honor, may we have a moment to set up the preparation for a demonstrative? It's simply a stand with a whiteboard, Your Honor.
Are you asking for some time? Are you asking if you can use it? What are you asking for?
If we can set it up in the well for use during the direct examination.
That's fine.
Thank you, Your Honor.
Opposing counsel, you're free to reposition yourselves where you can see the demonstrative when he uses it, so you'll know what's being done with it.
Thank you.
If you like to.
Thank you, Your Honor. May I just ask where you'd like us to go, just so I know exactly where to go and don't.
Right behind plaintiff's counsel, right behind Mr. Draper would be fine.
That sounds perfect. I didn't want to get too close to the plaintiff.
That's
without
fine.
noisily.
All right, proceed with direct examination.
Yes, Your Honor. Good afternoon.
Hello again.
Please introduce yourself to the jury and tell us what you do for a living.
I'm Dr. Lane Harris. I'm the head arborist for Sterling Family Nurseries.
Let's start off with the basics. What's an arborist?
Specialist in plants with bark, essentially. Trees, among others.
To become the head arborist, do you have any sort of educational background?
I have a PhD in arboriculture and forestry.
Doctor, are you familiar with the Waco National Golf Club?
I am.
How are you familiar with them?
I have installed trees for them over the last 25 years.
I want to talk to you a bit about that relationship. Your Honor, we're publishing Exhibit 18, which has already been admitted into evidence. Dr. Harris, do you recognize this?
Yes.
What is it?
It's a letter that I sent to Mr. Campbell for Waco National Golf Course after one of my first interactions with the golf course.
What's cabling?
Cabling is a technique to secure newly planted trees to stable ground. And what it does is it stabilizes them and would prevent something like a tree being blown over by the wind.
Did you ever inform Waco National about cabling?
Yes, first time I interacted with them, I told them that with new trees, the new large trees, the mature trees, that the standard practice was to cable them.
How did Waco National respond when you suggested cabling?
Borderline hostility. From my perspective, they made it very clear that under no circumstances would they ever consider disrupting, what they call disrupting the flow of traffic and golfers on the golf course to stabilize a tree with cabling.
Did you ever suggest cabling again?
It was made very clear to me that that was never going to be an acceptable option, and so there was no reason for me to get into it with them again.
So what did you put in this letter about that?
I basically just said, I want you to know, I told you this is the way that professionals prefer to deal with these situations, and you've told me you don't want to do that.
Thank you, Ms. Garabetian. You mentioned that something that you've done with Waco National is sell trees to them. Would you recognize an invoice for one of those sales if I were to show it to you?
Sure.
Your Honor, I'm approaching opposing counsel with what's been previously marked as Exhibit 24 for identification. May I approach the witness?
You may.
Would Your Honor like a copy as well?
Not at this moment.
Yes, Your Honor. Dr. Harris, do you recognize what I just handed to you?
I do.
What is it?
It's an invoice for a tree purchase that Waco National Golf Course made from us, Sterling Nursery.
And is this in substantially the same condition as the last time you saw it?
Yes.
Is this the type of document that you regularly produce as part of
Yes.
your business? Your Honor, the defense moves Exhibit 24 for identification into evidence.
Is there objection?
No objection.
None, Your Honor.
It'll be admitted.
Your Honor, we're now publishing Exhibit 24 for the members of the jury. I actually want to talk to you about something on the second page of this document here, Dr. Harris. That third paragraph that starts with indemnity and hold harmless. Would you please read just the first portion of that for us?
Sure. SFN, Sterling Family Nurseries, shall not be liable for any loss, damage, or injury of any kind or character to any person or property arising from any use of the subject trees or any part thereof, or caused by any defect in said trees, or caused by or arising from any act or omission of purchaser or any of purchaser's agents, employees, licensees, invitees, or sublessees, or from any accident involving such trees, or any fire, lightning, vandalism, malicious mischief, or other casualty, whether or not insured under the extended coverage endorsement thereon, or occasioned by the failure of purchaser to maintain the trees in safe condition.
Thank you, Doctor. Should be enough. Now I want to move on to another portion of that. Ms. Garabetian, would you please go to page 1 of the exhibit. What does it say there under additional terms at the bottom of page 1?
It basically says that once we plant the tree, Waco National Golf Course is entirely responsible for care, maintenance, and inspection.
Can we go on to the next page, Ms. Garabetian? Thank you. Once again at the top. So what was your understanding, Dr. Harris, of this agreement between you and Waco National?
We planted trees, and that was all once the tree was in the ground, our obligation was complete.
Did you ever go and inspect those trees for Waco National?
Well, I mean, yeah, because they were a customer, and, you continue the customer relationship component of the situation. And so, so they would keep buying trees from us. We would go down and offer to walk the course.
Was that part of any type of contractual obligation that you had?
No, there was no contractual agreement other than the agreement that we just read.
If you go back to page 1 of that document, Ms. Garabetian, did Waco National sign this document in agreement with you?
Yes,
Who was it signed by?
Mr. Campbell.
Thank you. When I want to move on to one thing that happened in this case, do you know what happened on April 8th, 2022 at the golf course?
A tree fell.
Did you ever get the chance to go and actually inspect the golf course to see what happened afterward?
Yes, I went down and looked at the situation.
And earlier, we've heard a few times throughout today's trial, Dr. Harris, about a conversation that took place between you and Rory Campbell during an inspection. What did you tell Mr. Campbell during that last inspection?
This is before the tree fell, right?
Yes.
Yes. I told him we'll walk the course, noticed that it was incredibly wet, muddy, and one of the things I pointed out that was a danger, presented a danger to the stability of newly planted trees, those that had been planted within the last decade, because they had not had an opportunity to extend the roots into the surrounding stable soil that would have then prevented something like what happened.
Would creating a demonstrative of this idea help explain your testimony to the jury?
I think so.
Your Honor, may the witness step down and make use of the whiteboard?
He may.
Pick whatever color you'd like.
Okay, so we have our tree.
You're going to have to speak up, Dr. Harris, since you're not near the microphone.
Tree, and then the way the tree is planted is soil is removed in an area about a little larger than the root ball that we've talked about that comes with the tree. We take the tree out of the ground and we preserve the roots that are there, and so then that comes in and has the root ball in it, and we drop that in the hole. And so all this dirt here is what we consider disturbed dirt, unstable dirt, because it's been, when we fill it back in, it hasn't had an opportunity to pack down and provide the same kind of strength, stability that the dirt surrounding that hole has. And so when you, sorry.
Dr. Harris, so what can happen when it rains to a situation like this?
So rains is, one way to think about this is, think of a tub of soft spread margarine. You pull it out of the refrigerator, right? You can stick a fork in it, and that fork would stay there. But then as the margarine gradually heated up to room temperature, the margarine would soften and liquefy, and that fork would fall over by itself. Now imagine if there's wind, say you had your ceiling fan on, when you stuck the fork in after pulling it out of the refrigerator, no problem. Then as the margarine heats up to room temperature, softens and liquefies, at some point that wind's going to topple the fork. And so that's the situation you have with the tree. The rain causes the soil.
Objection, Your Honor. Improper opinion, specifically, if I could explain, related to the wind testimony.
What's your objection?
Your Honor, it's an improper, expert opinion. Specifically, first off, this witness has not been tendered as an expert. So this is a lay opinion. So for this witness to go into what wind affects trees and how much wind that would be and equating it to somehow a ceiling fan in a tub of margarine. Well, Your Honor, this is a lay witness, and for them to state an opinion related to the wind is improper. They haven't been tendered as an expert.
Your Honor, may I respond?
Please do.
We didn't ask Dr. Harris to give any type of expert opinion to opine on what happened in this case. Rather, all Dr. Harris is explaining right now, generally speaking, is this idea of soupy soil at the base of a tree and how a tree can fall down. They're not giving any opinion as to what happened in this case, and specifically opining on what caused the tree in this case to fall down, just to the extent of what they explained to the Waco National Golf Club.
Well, this is exactly the kind of testimony that an expert would be called upon to give in this case. The fact that you didn't qualify this witness, even though he's your corporate representative, as an expert is on you. I'm going to sustain the objection.
Move to strike the offending testimony that preceded.
I'll strike the testimony about the explanation about water in the root ball, etc. You can continue to use the demonstrative if you can avoid asking for improper expert opinions. If not, then continue with your other examination.
Yes, Your Honor, then at this time, may we approach to tender Dr. Harris as an expert on this issue specifically of soupy soil at the base of a tree?
Not in the middle of a trial, counsel. If you're going to tender a witness as an expert, you're going to do it in advance of the trial where there's an opportunity for the expert to be challenged, their qualifications and their opinions. We're not going to do that in the middle of the trial.
Understood, Your Honor.
Your request is denied.
Thank you, Dr. Harris. You can take a seat. Okay. Dr. Harris, would you recognize a photograph of what you saw when you went to the golf course after the tree fell?
Yes.
Your Honor, I'm approaching opposing counsel with what's been previously marked as Exhibit 15 for identification. May I approach the witness with the same?
You may.
Dr. Harris, do you recognize what I've just handed to you?
I do.
What is it?
It's the tree that fell on the golf course, the aftermath, I guess, of the falling tree.
And is it a fair and accurate depiction of that fallen tree as you last remember it?
It is.
Your Honor, the defense moves Exhibit 15 for identification into evidence.
Any objections?
No objection.
No objection.
Exhibit 15 is admitted.
Now publishing Exhibit 15 for the members of the jury. Your Honor, we also do have colored photographs of this exhibit. Do we have permission to show these photographs to the members of the jury by handing to them?
There's no reason they can't see them on the screen as well as anything else. That's not necessary.
Understood, Your Honor. Taking a look at this photograph, Dr. Harris, what did you notice about how this tree fell?
Well, it fell with the root ball contained. So that means that root ball
Objection,
has...
Your Honor. This is going into an improper expert opinion about what that means.
Any response?
Yes, Your Honor. The witness was only explaining what seeing this fallen tree and just describing what he saw at the base of it. We're not intending to elicit any expert testimony from this witness opining on what this means and how the tree fell or the exact mechanism of that.
Restate your question then.
Yes, Your Honor. Dr. Harris, did you see evidence that this tree snapped in half?
No.
When this tree fell, how did it fall in relation to just the base of it?
The tree basically fell, the exact thing we planted fell.
Understood. Pass the witness, Your Honor.
All right. Cross-examination by the plaintiff.
Yes, Your Honor.
Please proceed.
Dr. Harris, I want to pick up by talking about that agreement that your nursery had with Waco National Golf Club. Now let's look at the bottom of page 1 of this. Now what this says is that your nursery is responsible for ensuring that the trees are in a suitable condition at the time of installation, right?
Yes.
And let's look at the next page, because what it says there is that the nursery is responsible for ensuring that the trees are suitable at the time after installation. Right there at the top.
That's not what it says.
or excuse me, it says that Waco National is responsible for the trees after you
It says the
install them.
golf course is responsible, yes.
So the nursery is responsible for installing them, right?
And then our responsibility ends,
And then your responsibility ends and Waco begins.
yes.
Thank you. I have nothing further, Your Honor. Pass the witness.
All right. Cross-examination by Waco National.
Yes, Your Honor. Ms. Schaefer, could we have Exhibit 18 up? Dr. Harris, you were asked about the letter sent in 1997 on direct examination, right?
Yes,
Now, I want to be clear about something in that letter. You testified on direct examination that you decided to not further talking about the cabling after this conversation, right?
I did.
You said in that letter, it was completely understandable, right?
I did.
The choice to not cable was understandable.
I did.
Pass the witness.
Any redirect from Sterling family?
No redirect, Your Honor. May this witness rejoin counsel table?
Yes, you may step down, Dr. Harris. And let's reclaim this exhibit.
Yes, Your Honor. May I retrieve the exhibits from Dr. Harris?
Do it, please. All right. Sterling family, call your next witness.
With that, Your Honor, Sterling Family Nursery rests its case in chief.
All right. All three parties have rested their cases in chief. Are we prepared to move to closing arguments?
Your Honor, Waco National is prepared. We would re-raise our Rule 50 motion if you'd like to hear it now or after close.
I'll hear it very briefly now. It's not likely I'm going to grant it.
Completely understood, Your Honor.
Rule 50A makes it clear that the court may grant, but the court's not required to. But for purposes of the record, make your motion, but make it brief, please.
Your Honor, we move for judgment as a matter of law as they failed to meet their prima facie case, even viewing the evidence in the light most favorable to the non-moving party, the plaintiff.
All right. Are there other motions from either other party under Rule 50A?
Yes, Your Honor. Sterling Family Nursery also moves for a judgment as a matter of law under Rule 50 of the Federal Rules of Civil Procedure, looking at the evidence in the light most favorable to the non-moving party, the plaintiff. The plaintiff has failed to establish that Sterling Family Nursery specifically owed a duty of care to the patrons of the Waco National Golf Club when they invited those patrons to their course.
All right. Is there anything under Rule 50A from the plaintiff?
Your Honor, we have no 50A motion.
All right. And I gather you oppose these two motions.
Yes, Your Honor, we oppose both.
The motions are denied.
Understood.
We'll proceed with closing arguments. Plaintiff, you may present your first closing argument.
Your Honor, if we could get a time check briefly before.
Plaintiff has 14 minutes, Waco has 20, and Sterling family has 10.
Yes, Your Honor.
You said 14, Your Honor?
Yes.
Okay.
And counsel, since you have the burden of proof, you're entitled to split your closing time and do a final closing after the defendants have presented their closings, if you choose to.
Yes, Your Honor.
All right, present your first closing argument then.
May it please the court,
Please proceed.
opposing counsel, members of the jury. This is a case about pride. And more than that, it's a case about pride turning to arrogance. Because you heard it for yourself over the course of this trial. You heard it from the defendant yourself, that everything they do on that golf course is, we were concerned about the aesthetics. We were concerned about beauty. We were concerned about the broadcasters. Members of the jury, those are the words of Waco National Golf Club. Because for Waco National Golf Club, it's all about pride. And pride cometh before the fall. Waco National knew that they had something special. They knew that they had a course unlike any other in the world. And you heard when every witness took the stand who was affiliated with Waco National how proud they are of their golf course. They have the best golf course in the world, and they know it. They run the best golf tournament in the world, and they know it. Everything about this course is to maintain that. Everything about this course is to keep it beautiful, to keep it perfect, to keep it flawless. So when it came time to add some new trees to the golf course, Waco National knew that planting seeds, planting saplings, wasn't an option. So that, as you've seen throughout the course of this trial, is why they approached the Sterling Family Nursery. That is why they found the nursery and asked them to transplant 100-foot tall pine trees out of a forest and into a golf course. And you also saw that when that decision was made, when the golf course decided that they couldn't wait long enough for a sapling to grow up, they needed a tree here and now, the golf course also decided not to follow the safety precautions. Because you heard that at the very beginning of this relationship, far back into 1997, Sterling Family Nursery told the golf course, there's a danger. If you don't stabilize these trees to the ground, something could happen. And on April 8th of 2022, something did happen. Because on that day, a tree came crashing down and crushed Mr. Casey Draper. That's why we brought this lawsuit. We brought this lawsuit not only because of the negligence of Waco National and not maintaining their course and not creating a safe environment for their patrons like Mr. Draper, we also brought this course because the installation of the trees itself was negligent. Now you saw it just a minute ago up on the big screen. You saw the agreement between the two defendants. And you heard this yourself from Dr. Harris when he was just on the stand. He told you that the nursery is responsible for installing the trees and that Waco National is responsible for everything after that. So members of the jury, let's break both of those down and let's walk through the duties, the breach, and the causation that both of the parties have. Now we showed you that Waco National had a duty to protect the visitors to their golf course. They had a duty, once the trees were installed on those golf courses and on that golf course, to maintain them, to keep them safe. And you saw that they breached that duty when they created a dangerous risk that a tree would fall. So how did they create a dangerous risk? Well, you heard from the experts today. You heard from an arborist. You heard from Dr. Olson, who has an entire research lab about trees falling. So let's walk through what you heard. You heard that there are several conditions that, when present, make it likely that a tree that's not stabilized and cabled into the ground will fall. You heard that one of those is soggy soil and the other is wind. And so on April 8th of 2022, what conditions were present on the golf course? You saw for yourself. There was soggy soil and there was wind. In fact, the groundskeeper himself of this golf course told you that on the afternoon, when the tree fell, on the afternoon of April 8th, they suspended play because of wind and because of soggy soil. Members of the jury, the conditions were present, and not only were the conditions present, the defendant knew about them. They knew that there was soggy soil because they suspended their golf tournament because of it. They knew that there were wind problems because they suspended the golf tournament again when the wind picked up. You heard from Mr. Draper when he took the stand. There was debris blowing around. The wind picked up. There was a hazard to those trees. But the golf course, they didn't send their fans off. They didn't make their fans evacuate. They kept everybody huddled into those tee boxes right in the woods. And why did they do that? Well, you saw for yourself. Because of pride. They did it for the broadcasters. They did it to maintain their reputation as the best golf course in the world. This kind of thing doesn't happen at Waco National. Now, not only was the golf course negligent in not calling it off for the wind, they were also negligent in not taking account of their soil conditions. Now, members of the jury, over the course of this trial, the defense has acted like they're running a library. They've acted like they don't have an entire maintenance staff that's working on the grass, that's working on the trees, that's working on every plant in that golf course every single day of the week at all hours. The defense has acted like they know absolutely nothing about landscaping, like they know absolutely nothing about how water works when it drops out of the sky and onto a golf course. Members of the jury, they knew the conditions of their soil. And even if the maintenance staff, even if Rory Campbell, the groundskeeper, had no earthly clue that a puddle the size of a lake on a golf course was dangerous, the Sterling Family Nursery put him on notice. Because when Dr. Harris took the stand, he told you that he inspected this course, he noticed the soggy conditions, he noticed the water pooling up, and he told them. He told them that this was a problem, and on top of that, he told them that this was a dangerous condition that could lead to a tree falling. That was a condition created by the golf course. And it was also a condition that was made worse by the golf course. Because for 45 minutes every day of the week in the run-up to this tournament, they had the sprinklers running. For 45 minutes a day, they were watering the course on top of the water that was already pooling up. And why did they do that? Because of pride. You heard for yourself. They did it for the azaleas. They did it for the grass. They did it for that green color that looks so good for the cameras. And what resulted? Casey Draper can no longer walk. Casey Draper can no longer stand. That's negligence. Now, Waco National is not the only party that we've sued in this case, and they're not the only party that's negligent in this case. Now, members of the jury, you've also seen that the Sterling Family Nursery is also negligent because they owed a duty to safely install the trees on that golf course. Now, over the course of the trial, when the representatives from the Sterling Family Nursery got up to take the stand, when Dr. Harris took the stand, they said that as soon as Waco National said that they didn't want to put cables on the trees, as soon as Waco National said they didn't want to stabilize these trees, then the Sterling Family Nursery brushed their hands off and said, we're through here. We're good to install as many trees as we want, however we want, and however you want us to. Members of the jury, that's not an ordinary standard of care. That's not the ordinary care that this nursery had to follow. You saw how they breached that duty of care. They did exactly what Waco National wanted them to do. Members of the jury, if Waco National asked this nursery to jump, the first question out of the nursery's mouth wouldn't be, why? It'd be, how high? Because you've seen over the course of this trial that this nursery did everything at the bidding of Waco National. And why is that? Because this was their largest contract. This was one of their oldest clients. This was the client that paid them to install 100-foot mature pine trees on a golf course. Members of the jury, that is what caused this to happen. The defendants knew the risks. The nursery knew that not cabling these trees, that not taping them down into the ground, not stabilizing them, could create a risk of a fall in the right circumstances. And when the nursery went out to inspect, they saw that the right circumstances were there. But did they make suggestions? Did they make safety precaution recommendations? No, they let it be. And even when Waco National then had noticed that something was wrong with their golf course, that there was a danger, they ignored that as well. At the start of this trial, I told you that this case is about collaboration. Members of the jury, it is. It's about the two defendants collaborating together in their ignorance of risk. It's about the two defendants collaborating together and ignoring danger. And that is why Casey Draper is in a wheelchair today. That is why Casey Draper, when he took the stand, couldn't walk up there. Members of the jury, that is why we ask that you find the defendants liable. Thank you.
All right, next we'll hear a closing argument from Waco National.
Yes, Your Honor. May it please the court. Do we have the court's permission, before I begin, my apologies, Your Honor, to display portions of the jury verdict form as well as the jury instructions and any
Yes.
admitted exhibits?
Yes.
Thank you. Four witnesses took the stand today. And now, while they obviously didn't always agree about every fact. There was one fact. All 4 of those witnesses had to agree on it. In 2020, Sterling Family Nursery said the trees were safe. In 2021, Sterling Family Nursery said those trees, they're safe. 2022, just 4 days before the accident, Sterling Family Nursery said, we inspected the trees, they passed. You're A-OK. When Waco National started the Legends Tournament, when they allowed guests into their course, they did that because they believed their trees were safe. They believed that because they're experts. The Sterling Family Nursery, they told them that. And Waco National entrusted the experts. Today, the plaintiff had the burden to prove their claim by a preponderance of the evidence, more likely than not. And they had to prove Waco National was negligent. That means they had to prove Waco National failed to act as a reasonable golf course would. But members of the jury, I want to walk through the 3 reasons they couldn't meet their burden today. Reason 1, the experts installed the trees. The plaintiff said, well, those trees, they weren't installed securely. But even if that's true, that's not enough to meet their burden. The judge is going to instruct you. They had to prove Waco National failed to do what a reasonable golf course would do, not a reasonable tree expert. So what does a reasonable golf course do when they're looking to plant some new trees? They bring in the experts. The plaintiff said, well, these trees at the 17th hole, they weren't installed securely. They weren't secure. But here's the problem for the plaintiff. Waco National didn't install any of the trees at the 17th hole. They didn't install the tree that fell. That was all Sterling Family Nursery. But then the plaintiff wanted to say, well, Waco National, they're responsible for what happened to that tree because, after all, they own the golf course. Members of the jury, if you hire a contractor to fix up your bathroom, and then the first day you walk out of the shower, one of the tiles slips, you don't toss your hands up and say, I guess that one's on me. After all, I own the house. No. When you hire experts, you expect them to get the job done right. Reason 2, the experts inspected the trees. So what does a reasonable golf course do when they have some new trees planted and they want to make sure they stay safe, particularly when they're going to have a bunch of people coming in for a golf tournament? Well, they have the experts come out and inspect them. And that's exactly what Waco National did. They had the Sterling Family Nursery come and inspect those trees every single year, right? Fine. But that takes us to the 3rd reason, and folks, this is where we're going to spend most of our time here. The experts didn't tell them there were any problems with the trees. Dr. Elaine Harris took the stand today a couple times. And Dr. Harris in court today said, oh, those trees were dangerous. But that's not what Dr. Harris said back in 2020 when he examined the trees. That's not what he said when he examined the trees in 2021. That's not what he said when he examined the trees in 2022, just 4 days before the accident. 2021. No issues with the trees. No major safety concerns. 2021. No issues with the trees. No major safety concerns. In 2022, 4 days before that tree came down, Dr. Harris said, this is my official inspection. This is the report. I do not find any issues with any trees on the property. No major safety concerns. Dr. Harris on the stand today tried to tell you those trees were dangerous. But members of the jury, before this accident, Dr. Harris said, those trees are safe. But after the accident, oh, that tree I installed, the one I inspected, it was a death trap. So what happened? I mean, you heard Dr. Harris's years of experience. You heard his PhD in forestry. This guy knows his trees. He's an expert. They say he somehow missed some major safety concern with these trees in 2020, in 2021, in 2022. Or rather, did he change his tune when, well, his company is getting blamed for their actions, is being held responsible for their actions? Because members of the jury, if he missed the issue, Waco National's not liable. His company is. He's the expert. And if he changed his story, Waco National isn't liable either. Because they were never told. He made that story up now. Then the plaintiff said, well, Waco National should have had cables on their trees. They should have cabled them. But could they point to a single other golf course that has cables on their trees? Could they name a single one that does that? Could they point to a single academic journal, article, a textbook that says cabling trees is the industry standard? That's what's required. That's what makes trees safe. And they said, well, take a look at this letter. Well, in 1997, Waco National was told about cabling. Well, folks, when Waco National was told about cabling and they refused, they declined. It's not like Sterling Family Nursery said, whoa, if you don't cable, we're not going to install those trees. Too dangerous. If they truly believed that not cabling the trees was so dangerous that it could potentially kill someone, that it could cause a tree to fall over, why did they keep installing trees anyway? But more importantly, why did they allow it to pass safety inspections? Would a mechanic hand you back your car keys without brake pads or rotors and say, hey, listen, I told them driving out without brakes is dangerous. But you know, customer gets what the customer wants. Of course not. Because when experts know something is so dangerous it could kill someone, they don't let people have that choice. They don't let it pass safety inspections. Throughout today's trial, they've been telling you, both the plaintiff and the Sterling Family Nursery, they've told you things that Waco National should have known. In their opening statement, the plaintiff said they should have known the conditions were right for a tree to fall. They should have known the conditions were right for a tree to collapse. They should have known they needed the roots to stabilize it. They should have known there was a safety risk with that tree. They should have known the tree was at risk of falling. Members of the jury, what evidence did you hear Waco National was ever told any of those things? What evidence did you hear Waco National was ever informed by their experts the tree was at risk of falling? The soil was wet enough it could have killed someone. They needed to cable the trees. Otherwise, someone could die. And then, Sterling Family Nursery said, Waco National knew the ground was too wet and it made it unsafe. But members of the jury, it's funny. It's funny that Sterling Family Nursery's lawyers today would tell you things Waco National should have known when their own experts didn't bother to tell Waco National that before this accident. Now, it's true. What happened to the plaintiff was terrible. And members of the jury, it wasn't his fault. But when you go back into that jury room and when you go back and deliberate, you're going to have to answer two questions. And because you know Waco National didn't do anything outside what a normal golf club course would do, relying on the experts, you can write no under question 1 for Waco National. And under Sterling Family Nursery, you have to ask, did they do what a reasonable expert would? Would a reasonable expert make a suggestion, never follow up, if it was so important? Would a reasonable expert pass safety inspection after safety inspection after safety inspection if they knew the trees were dangerous? Would a reasonable expert say, there are no safety concerns, and then say, well, except for the ones they should have known about, we didn't tell them about? Because they failed to do what a reasonable tree expert would? You can write yes next to Sterling Family Nursery. Maybe Waco National shouldn't have had people sitting under those trees. Maybe they should have had some warnings about that particular tree. Maybe. But members of the jury, they didn't. Because they're experts. Never told them. They didn't know. They didn't do any of those things because they didn't know they needed to. Because they had no idea this would happen. They entrusted the experts. Find them not liable. Thank you. Thank you, Your Honor.
All right, Sterling Family Nursery, you may
Yes.
present your closing argument.
Yes, Your Honor. Folks, before any of us walked into this courtroom today, there's something that we can all agree on. When you invite people over onto your property, you're responsible for keeping them safe. You see, throughout today's trial, you've heard experts being thrown around. You've heard so many different individuals from this golf course and from this tree nursery talking over each other and disagreeing about what really happened. And somewhere along the way, the real reason that we're here got a bit lost. We're here because Mr. Draper went to that golf course, was excited to watch a tournament, and left with a life completely changed, where he can no longer walk. He can no longer do the things that he's passionate about, like golf, of course. And while Waco National told you over and over and over again today that they relied on the tree experts, they said so alarmingly little about what Mr. Draper relied on. How Mr. Draper relied on the golf course to keep him safe when he paid them to go watch the tournament they were hosting. When he beat out all those other people and won that lottery to go to the most prestigious golf tournament in the world. Mr. Draper relied on the golf course, and they failed him. Throughout today's trial, you've seen that the golf course had all of the control. They chose where to plant those trees, when to plant those trees, and how to plant them. But now, they don't want to face any of the consequences. You see, in a few minutes, you're going to get to see something called a jury charge. Judge Gilstrap is going to show you this type of form right here. And it's got a few definitions of the words that lawyers like to throw around, like negligence. And I want to focus on one of them in particular. Negligence, when used with respect to the conduct of Waco National, means failure to use ordinary care. Failing to do that which a golf course holding a golf tournament that allows spectators onto the course of ordinary prudence would have done under the same or similar circumstances. It's so important, members of the jury, that when we're deciding the issues of this case, we're holding everybody to the standard of what would be reasonable for others under the same or similar circumstances. And today, we've shown you that the party with the ultimate responsibility for what happened to someone like Mr. Draper, a guest attending a golf tournament, that responsibility stayed with the golf club and only the golf club. And to show that to you, as promised, the evidence established two things in today's case. First, that Sterling Family Nursery reasonably advised Waco National on what to do with those trees. And second, that it was the golf course that failed to take those reasonable steps to protect their guests like Mr. Draper. So let's start by taking a look at that first point, that Sterling Tree Nursery reasonably advised the golf course on what to do with those trees. One of the first documents that you got to see today, members of the jury, was that letter from back in 1997. And today, when I was cross-examining Rory Campbell, the head groundskeeper for Waco National, I asked him about that line, the one that Dr. Harris made sure to put in this letter. I noted that none of the newly planted trees at the golf course are cabled to the ground, which we would think of as standard procedure with a newly planted tree until that tree's been in the ground for 8 to 10 years and had a chance to develop a stronger root system. That's what the nursery made sure to tell Rory Campbell from the very beginning of their relationship. And now you know how Mr. Campbell felt about that. For him, cabling was a non-starter. It didn't matter if cabling would have made those trees safer. What mattered is how that golf course looked. What mattered was their reputation as the world's most beautiful golf course. Now, Waco National tried to tell you over and over again, well, the tree nursery should have warned them more. Should have kept repeating to them, you should cable your trees, you should cable your trees. Folks, you can't expect the tree nursery to care more about the golf course's patrons than the golf course itself. That's just not reasonable. But that's not all. Because you also know that the golf course failed to take reasonable steps to keep their guests safe, which brings me to my second point. Today you found out that Rory Campbell was aware, at least he thought, members of the jury, that leading up to this golf tournament, Waco had been experiencing more rain than they've experienced for the past 20 years. You saw this photograph of the golf course. Exhibit 40. You can see here that there's so much water on that course that it's floating above the soil. And while Rory Campbell sat on that witness stand and tried to play it off like he's got no idea about things like soil or trees, remember who this is. The head groundskeeper for a golf course with 60 years of experience. Mr. Campbell saw that and decided to water that golf course every day, twice a day, 45 minutes, up until the very day that that tree came hurtling down onto Mr. Draper. Is that reasonable? Dr. Harris might have been the tree expert. Rory Campbell was the golf course expert. Where's the reliance on him? The golf course made decision after decision that put their guests at risk. The decision not to warn them. The decision to plant those trees without cabling right above their heads as they're watching that tournament. The decision to prioritize how their golf course looked over how safe it was. That's why they should be found liable. So when you're presented with these questions in just a few minutes.
You have 2 minutes remaining, counsel.
Yes, Your Honor. And you're asked, did the negligence, if any, of either of the parties named below proximately cause Casey Draper's injuries? We'd ask that you place a yes next to Waco National Golf Club. Because while the nursery planted those trees, the golf course decided exactly what to do with them. They decided that they didn't need cabling. They decided to install them right next to those tee boxes. They decided to allow guests to sit right underneath them, even though they knew that they weren't as secure as they could be, because it wouldn't be as pretty. And when you're asked about the negligence of Sterling Family Nursery, the answer is no. Because while they planted those trees, it wasn't their responsibility to make sure the guests at a golf tournament are safe. In the same way that you can't fault Mr. Draper for relying on the golf course to keep him safe, you can't fault the tree nursery for selling products to the golf course in the form of trees that they didn't care about as far as their safety. That's why we ask that you find the golf course liable, because they've shown you that they had all of the control. They don't want to face any of the consequences.
And if you have 3 minutes remaining, do you wish to present a final closing argument?
Yes, Your Honor.
Please proceed.
If there's one thing clear from the blame game of round robin that we all just watched, it is that the liability of the defendants in this case is not at issue, because both of them just proved it for you. And when you go back to your jury room, the answer to both of these questions of who is responsible is clearly yes for both. What this case does come down to, though, is how we distribute who's most at fault. And that's why, members of the jury, we're going to ask that when you go back to your room, that you find that Waco National Golf Club is 80% responsible for Mr. Draper's injury. That's also why we're going to ask that you find that the nursery is 20% at fault for this injury. Now, a little while ago, you heard an example about stepping out of a shower and slipping. But members of the jury, if I step out of the shower in my bathroom and I slip on a tile that I told the contractor to improperly install in the first place, that is on me. And that's exactly what Waco National did. They told their contractor, they told the nursery to improperly install those trees, and the nursery went right along with it. That is on them. That is why we ask that you find the defendants liable. Thank you.
All right, ladies and gentlemen of the jury, you've heard closing arguments from counsel. You've received the court's final instructions on the law. You may now retire and deliberate on your verdict. The court stands in recess.
Be seated, please.
Council, let me say it's been a privilege to be with you today. And let me also say that you are all miles ahead of where I was 100 years ago when I was in your places. I see a lot of potential in all of you. I've been told that I'm to give very brief comments and then the members of the jury will, and then after comments have been made, I'll announce the winner. The only comment I will give is nobody thanked the jury. Always thank the jury. They're working hard, they're trying to get it right, and the least you can say at some point before you sit down is, ladies and gentlemen of the jury, thank you so much for the effort you put into this trial. I've got other comments, but that's the main one, and I'll turn to Professor Powell. You have comments for the panel?
I'll just have one. I enjoyed it very much. I thought you did a great job. I was a little bit concerned in closing argument with all of you. In my mind, there's one jury question that decides the outcome of this case, no matter how you slice it, and nobody talked about it until the rebuttal, and I was just stunned. I mean, the jury charge and the verdict form are the structure of your closing argument. You know, that's the guideline to follow in what you argue to the jury, and I felt like we didn't hear much of that. And without some kind of a causation defense, somebody's going to get tagged. It's just a question of how much to each defendant at that point. And you certainly care because of insurance issues. So I can see why you argued it in rebuttal. While it put them in a disadvantage, it did put them in a disadvantage because they didn't have a chance to respond to you. You shouldn't have let him do that. Neither one of you should. I mean, you got to tell the jury when they split the baby, and they will in this case, I think, how much we're going to split it. And that decides how happy you're going to be hereafter, sir. You know, are you going to be sitting a little easier in that chair or not? It depends on the percentages. So anyway, the jury charge and the verdict form are always the most important thing in closing argument.
Number one is I'm always impressed with this competition and how good all of you are. And I don't just say that because I've said it in the past too. I say it because I really mean it. I think you are all great. And I'm going to limit to just very small things because there's not a whole lot to criticize any of you about. And not that I'm here to criticize. On the plaintiff, and I'm sure probably if you others been the plaintiff in some of the other cases, you're always looking for a mad fact, because the fact is, in the end, what you're looking for not only is a liability finding, but you want damages, and you want good damages. And a mad fact in this case, and it's a small thing, but it kind of fits with your theory, and your theory too, and that is on that chart that showed the watering, even after this tree fell and they've had this catastrophe, they're still watering the damn place at 8 o'clock at night, you know, the night after the tree had fallen and caused a problem. So I would add that to the arrogance list, and that's just a small thing, but it's something I'm always looking for as a plaintiff. It's something to make them mad. Mr. Doig, on the objections, I know we're kind of in a little bit of a false setting because you got to find something to, I mean, you know you're going to be judged on, you know, evidence and how you present it. And so but I would watch objections in a real trial, especially when both sides are pointing at you. You're kind of the target in the middle. But I realize you're doing some of that for us for grading purposes, or I think, because there's some of the objections you made, I don't think you'd make it in a real trial. So I'd watch making objections to things you know that the judge is probably going to overrule, okay? And especially on close calls on evidentiary matters, save it for something that you can really use. And I don't want to mispronounce your name, Hussaini? Hussaini? Mr. Hussaini, I thought you did a really good job of taking what's given you as being a third party and deciding that you're going to join up with the plaintiff, who's the sympathetic factor in the case, and draw a little of that sympathy to you too. And I thought you did a really good job with that. One thing for all of you, don't call the plaintiff, call him by his name. I think that's important, and because it's a way, you're humanizing people, and whether you think they're, especially in a case like this where you're really kind of conceding that he didn't do anything wrong, call him by his name. That's all I have. Great job.
Yeah, I got to echo what they said. It was a lot of fun to watch. I'm a plaintiff's lawyer, and I got to say, I would love a case to be in this plaintiff's shoes where the defendants are just arguing against each other, and I can just sit back and relax. If I could say one thing that applies sort of equally to all three parties, it is you guys have to grapple with your bad facts. I think y'all were very good at latching on to the stuff that was good for you and going back to it, but you really have to, from the get-go, and grapple with the things that hurt you. And I don't want to go into nitpicky, but I have a list of bad facts for each side. If you guys really want that, you need to kind of grapple with. That would be my going forward tip.
Again, I'll echo all of that. Y'all all did a great job. I would say from you, I wanted to hear a little more about the plaintiff. I know it wasn't a damages case, which is probably where more of that would have come in, but you were a great witness. You were a very happy guy, but I wanted to hear more sad, things you can't do with your kids. You can't teach them to golf, things like that. But I thought you did a very good job of keeping your case simple. Just very much, this is not his fault, just very clear. So I really liked that. You, I thought, did a very good job of focusing on, what they didn't tell you. I really liked your theme about, we hired the experts and we relied on the experts. So I got a little confused when you stood up and objected to their guy being an expert and not letting him talk about the tree and the margarine, because I think you should have let that happen and then said, did you sit down with my client and draw a pretty picture of a tree? And did you talk to him about margarine? And you know what I mean? I thought that was a little inconsistent. And then you stood up in closing and told me he was an expert. And I'm like, what? You have probably what I thought was the best, speaking style. It was just very calm. You didn't get angry. So I thought you were just really, really persuasive on things like that. You did have some crosses. Dean Tobin got the best of you. You ended on a bad answer, and I would have liked to have seen you come back on that. Well, you didn't tell him. You didn't keep telling him. Because I'm trying to remember exactly what he said. The other thing, he said something about waste of money, and I would like you to have seized on the money. Oh, this is about money, because I think he kind of gave you that. So.
I think I wish that we had the opportunity to interview everybody like this, to do it this way, to put everybody through something like this, to see the talent that people have, because you guys were tremendous. And I applaud both you and those that helped make this happen, because there are other people that are under a time crunch that are trying to throw up the right exhibit. So good job to the support that helped on this deal too. That's phenomenal. And I've been in trials where not so much. And so you worry that exhibit's not coming, and you guys were able, because of that support, you guys did a great job. It's very impressive. If I was to say something that applies to everyone in the deal, there were gifts that were given, not the planned things, not the scripted things, but there were gifts that each and every one of those witnesses, and they're professors and people that I respect, but they all still gave gifts with what they were saying. Some things that were remarkably maybe dumb from the standpoint of the testimony, that the opportunity for you. One of you was trying to establish, of course, that it was super wet, and there says rainy spring, and instead, hey, I'm trying to get this log in. If I can, just seize on that. And then you started with the rainy spring, but he'd repeated it a couple times for you. You've got the great opportunity with the advice, the old advice that was given. There was a book written a long time ago called Common Sense. It didn't expire, and neither does the good advice that we have. And that good advice, it had no expiration date on it, right? And it was still there. And so you had that great advice that was given, still given today, and people should still follow the good advice and stop ignoring it, right? And so listen, seize those opportunities. Try not to get buried. I know you guys did better with this than I've seen with people that have cases for weeks or months and sometimes years. You took it, you embraced the facts. You didn't even slaughter the names of the fake people. That's impressive. And so to be able to focus like that, and then in this big moment to do that here and now, just take that to the next level and focus on listen to what that person's saying. Forget about everything else. And then when you hear that, realize there's my opportunity. Take the safe places and take them to the place that they decided to go. And you'll have opportunity with those disasters that they've created for you. Thank you, guys.
All right, before we announce the winner. Oh, I'm sorry, I didn't mean to cut you off. Go ahead.
Thank you, Your Honor.
That's what happens when you're on the back row of the jury.
I thought everyone did. Articulate. A couple things that I noticed. I think there were some details in the document. Maybe this is on again. You did a good job using the documents, talking about the documents, but for example, in the water log, you mentioned that March is the heaviest rainfall month, or the March of, or more. That's it, thank you. But it's like 3 times any other month. And there are different ways that you could talk about that number and make it meaningful by focusing on those details. Similarly, there was the official inspection reports, and it talks about, and it's not just that they're safe trees, it says concerning the spectators and having your volunteers and staff and all those people out there on the course. I mean, that shows additional knowledge and what they're thinking. This isn't just, is the tree gonna fall over or not? It's an additional level of knowledge. And so those kinds of details can make the exhibits much more meaningful. My biggest concern from any of you was the strategic call of the defendants pointing fingers at each other and not trying to escape this at all. I understand under these circumstances it made sense, and I thought you guys all did a really good job to bring this all together. The cross-examinations, though, that was the one other. There's some technical things, I think, about being able to control the witnesses and using the deposition. I think you guys knew the deposition transcripts and were trying to talk about them, but not confronting the witnesses with them to try and get them where you wanted them to go. Or like he was talking about following up and pushing them in a direction that was like a logical conclusion of what they were saying, but trying to control those witnesses who were very difficult, granted, but that was a technical aspect I think that you should consider working on for next time, but it was all excellent.
All right. First of all, this case should be in the Eastern District of Texas where we have pine trees. I don't know why it's in the Western District of Texas. Second of all, I want to share with you the best piece of advice I ever got as a young lawyer, and I hope you'll take it with you. Lawsuits are a race for credibility, first with the court and then with the jury. Always remember that. All right, we have some comments from Professor Little and Dean Tobin. Professor?
I know y'all really don't want to hear who won, so a few more things. I want to take a second to introduce the judges for this competition for today's final round very quickly, I promise. Judge Gilstrap from the Eastern District, who is always eager to come help us and judge this final round, has judged many Top Gun final rounds and always does a good job keeping it moving. Jerry Powell, our longtime evidence professor here at Baylor Law, recently retired, and hopefully y'all got a chance to see him in the video, be hilarious. Mark Mann, who's a plains lawyer from East Texas and an alumni of ours and always comes back and helps out whenever we need him. And we're always so thankful for that. Tom Jacob, plains attorney down in Austin, who does a great job and always shows up for us and was on the very first team I ever coached when I was coached in 2008. Sarah Shillette and John Adams from Lynn Pinker in Dallas, who came down. Oh, I thought you, I'm sorry. Okay, you were. Okay, I did not get that part wrong. But who came down today, Judge. We so thankful when y'all do. Always appreciate it. And Jordan Mayfield, who is a longtime partner of mine in Naaman Howe and a good trial lawyer and showed up to Judge today. So a really great panel of people who've tried a bunch of cases and know what they're talking about. And thank you all so much for being here. We really do appreciate it. And now I'm going to hand it over to Dean Brad Tobin for brief thank yous to some of the people who helped with the tournament.
You have 30 seconds, counsel.
Known for being loquacious. First of all, I want to thank Chief Judge Rodney Gilstrap of the Eastern District of Texas. Thank you, Judge, for being with us this weekend, taking time away. And I understand, and for those of you not from Texas, Marshall is just a little less than 4 hours away, and the judge is seating a jury in the morning, first up. So thank you, Chief Judge Gilstrap. So appreciate it. And I also want to thank MG&M. Mr. Bill Schultz, please stand up. Thank you. MG&M is our sponsor for the competition and has now have a multi-year partnership with Baylor Law School. And we are so appreciative to you and to each of your partners, Bill. Thank you so much. And then this type of competition comes off because of months of planning. And I'm going to read some names here. Most of them are not in the courtroom right now, but they need to be recognized because they start worrying about Top Gun about 6 months out before it ever unfolds. Some are here. First of all, Robert Little. Robert is the poobah of all things Top Gun. Kathy Sayre can't be here, but she's our warrior in chief for Top Gun. And Samantha, you're here. Samantha Smith, there you are, right there. Samantha takes care of all manner of logistics. And then very quickly, problem formulation, witness coordination, all the things that go into making this a top-notch competition. I want to thank my colleague Stephen Rispoli, Nick Texera, Ed Nelson, Rick Soll, Ricky Levesky, Chris Griesmer. And today, since they're in the courtroom, although I've had several colleagues who have been witnesses, I want to point out Dean Pat Wilson and Professor Larry Bates. Yes, he is a professor here, for those of you who have any doubts. Then we have students, alums, Megan Baumhart here has been at the center of all things organizational. Thank you, Megan, for extremely smooth competition. And she's been assisted by Waverly Shannon, Tanner Sheaf, Rachel Hales, Asna Poomwali, Nick McHenry, and Laura Cook. And I hope that I have covered everyone. I probably have not, but I want to emphasize that this competition is a event that at Baylor Law School we place great emphasis on. And now, many, many years down the line, I think that we still can claim that this is the highest profile mock trial competition in the nation. That's what we set out to create, and that's what we have, and it's because of the efforts of so many. And my final sentences here are, wow, yes, you can always get better. I hope that we all understand that every day when we get out of bed, that in whatever we're involved in professionally or personally, that we can get better, we can do better. But what a display of gifts and talents from younger lawyers that we have seen today. We're so proud of each one of you. You're all going to win. Chief?
All right, without further ado, the winner of today's or this year's Top Gun competition is Nicholas Lewis of the University of Georgia. I believe we have a presentation. Dean?
Robert? Okay, I got a couple things here to present. Nicholas, come forward, please. This is the golf tournament, and hence, take it off. There we go for the iconic picture. With your red tie, you look a little bit like Christmas today, Nicholas. And then, with thanks to our sponsors, NGM, Bill, thank you so much. Come up here because we want to get a photo. This is the $10,000 prize money that will be going to Nicholas. And with that, we're going to close. Jurors, thank you, thank you, thank you. You have taken your weekend, your Sunday, to be with us to provide the type of judging that the Top Gun competition is known for. So appreciate it. And the judge, the chief, needs to get on the road, so this will be the end of the formal aspects, and please feel free to stay, tarry, and visit. Thank you.